hearing outside the presence of the juries. Neither jury is present at this point. And the issue to deal with, according to the request of counsel, is the exhibits that will be used during the testimony of the next witness, the medical examiner, and specifically photographs. Are the parties ready to proceed?
Yes, Your Honor.
Yes.
All right. And how did you wish to proceed?
Judge, it's our position that the people who are offering these photographs, that the initial burden would be on them to establish some relevancy to the photographs, and then we would have some brief questioning of Dr. Golden regarding some of the photographs. And then we'd be prepared to argue that.
All right. You have seen all the photographs that the prosecution is attempting to offer.
I have, yes.
And are the people ready to proceed then?
Well, Your Honor, yes, I was going to proceed by way of argument and rely on the points and authorities that I had submitted to the court earlier in regards to why these photographs are relevant to explain the testimony of the autopsy surgeon. Do you want the autopsy surgeon to explain that they're relevant, or can we just argue it on?
If you feel that you can adequately present your position without testimony of the witness, you may do that. And if the defense wishes to controvert your representations, they can call the witness.
All right, well, he is available, and I would submit it on the moving papers. I think that the case law is very clear. I think the case law is very clear that those who have committed these types of crimes, it ill behooves them to complain of the carnage that they leave, number one. Number two, that people have attempted to call out photographs which show the most possible wounds in the least number of photographs. And it's very clear now that the number of shots fired is going to be a contested issue in this case. And the trier of fact does not have to rely solely upon description, but they in fact should be allowed to see the wounds as they exist. And we have attempted to pick photographs that are as descriptive without being bloody as possible. There is one photograph in the packet which is from the crime scene, because the coroner's office does not have complete photographs of all the wounds. There was evidently a roll of film that was either overexposed or somehow destroyed in this case by the coroner's office. And so because there are no photographs of the shotgun wound to the right forearm of Mr. Menendez, I thought it was important that the jury be able to see that. And because of the fact that the number of shots fired appears to be an issue that's going to be contested, I think that the prosecution is entitled to prove the nature and the manner in which the wounds were inflicted. The fact that some of them were contact and some of them were from several feet away also will be helpful in an understanding of Mr. Linhart's testimony. He's the forensic serologist who's going to be testifying after Dr. Golden testifies. So I think the case law is clear that it's not abuse of discretion for the court to admit photographs to aid in understanding the testimony of the autopsy surgeon. I'm sure that Dr. Golden could probably testify using just the diagrams, because when he performed the autopsy, he in fact created diagrams, and we have blank charts here, one for each of the juries and one for each of the victims. But it's not just whether or not Dr. Golden can explain it using just charts. It's whether or not the jury is entitled to understand this testimony through the use of photographs.
All right. Does the defense wish to respond?
Yeah, sure. Just to put the matter in perspective, I don't think there is any general rule that because the court allowed photographs in some other case, that therefore in every other case, bloody photographs can be admitted into evidence. This is a case where the cause of death, that is multiple gunshot wounds as to both victims, is not in dispute. The manner of death, that is death at the hands of another, is not in dispute. The fact that there are multiple gunshot wounds and the location of those wounds is not in dispute, because those are facts that are not subject to being in dispute, since they're well documented in the notes of Dr. Golden and will be testified to by him as to the location of the various wounds. One point that the prosecution raises that is in dispute somewhat, although even here it's not a central issue, is the number of shots that were fired. The number of wounds that were inflicted is not subject to controversy, but the number of shots may be a collateral issue in this case. But I don't think the photographs speak to that issue. Dr. Golden can testify that the photographs show where the various wounds were inflicted, but he cannot, I don't believe, and I'd be willing to make an offer of proof in that regard. He cannot, from the photographs, tell the number of shots fired. And we have had testimony from Mr. Van Horn indicating that his examination of the ballistics evidence indicated to him that at least 8 shots were fired here. And I think that Dr. Golden's testimony will be that there were 5 wounds inflicted on Jose Menendez. There were a total of, 6 wounds inflicted on Jose Menendez, but I also believe it would be his opinion that there were perhaps 5 separate wounds, that one of those wounds is associated with one of the first 5. And as to Mary Menendez, I believe his testimony will be that there were 10 or perhaps 11 wounds inflicted on her, and that the number of wounds inflicted does not necessarily indicate the number of shots that were fired, and that he has no way of determining the number of shots fired based on his examination, either in the autopsy room or based on his examination of the photographs, that is an issue that he cannot determine from looking at the photographs. So given that testimony, we're left, I think, with bloody and gruesome and gory photographs which are being put into evidence for no purpose other than supposedly to illustrate the number of shots. And it's our argument to the court that those photographs do not illustrate that point. There's another aspect to this case that I think is somewhat unusual and takes it out of the realm of the cases cited by the prosecution, which is that these photographs, or most of these photographs, were not taken by the coroner's office. They were taken by the Beverly Hills Police Department. And I would make an offer of proof to the court that when I interviewed Dr. Golden fairly early on in this case, and we had a discussion of his various findings, that he consistently throughout that interview referred not to the photographs, but to his diagram of the injuries, and that those diagrams are the best indicators of what his findings are. And in fact, there are findings indicated in the diagrams that are not reflected in the photographs, as indicated by Ms. Zanish, who says that they don't have corner photographs of certain of the injuries. And I think Dr. Golden's testimony would be that all of his findings are accurately reflected in his diagrams, and that they are not accurate, all of the findings are not accurately depicted in the photographs. In addition, Your Honor, because the photographs were not taken by the coroner's office, I believe that as to some of those photographs, there are depicted wounds which are wounds inflicted by the coroner or his assistants during the course of the autopsy. That is, they are artifacts from the autopsy procedure itself. And it's our position that those photographs would be misleading to the extent that they would suggest that those wounds were associated with the incident itself. And I would be prepared to call Dr. Golden to identify those wounds which I believe are autopsy related. One other point I wanted to add, there is in dispute, obviously, the issue of malice and premeditation and deliberation. But again, there is no dispute as to the number of wounds that were inflicted and as to their location. And those wounds can be testified to in detail, and I'm sure they will be testified to in detail by the coroner. And having established the location of those wounds and their nature by describing them as contact wounds or distant shots or close range shots, and indicating descriptively that those wounds were large in size or small in size or scattered, the coroner, I think, can paint a very good picture for the jury, and all the picture that the people need to paint in terms of how many wounds were inflicted, where they were inflicted, and that testimony could obviously be used on the issue of malice aforethought. There would be no additional reason to throw off or prejudicial photographs in our view.
All right, and you're speaking on behalf of both defendants?
Yes.
All right, and what is the people's response?
Well, Your Honor, I think the case law is clear in this regard. I think we've cited over 50 Supreme Court cases to the court which uphold the introduction of photographs, even if they are gory. And there's, in some of our points and authorities, a brief citation of what was depicted in the photographs.
All right, I will look at your points and authorities again. If these are the points and authorities you filed a couple, 3 months ago, is that right?
Yes.
Okay, I haven't. You didn't remind me that that was the document that you wanted me to review before today's
I'm
hearing.
sorry, Your Honor. Do you want me to go get a fresh copy?
I'm sure I can find it. What I did look at was the photographs, because that's what you asked me to look at.
In addition, Your Honor, the cases hold that that the people are entitled to prove malice, they're entitled to prove premeditation, and the photographs which depict the wounds are relevant to show those issues. And so I think that the photographs are very relevant in this case. We have made an attempt to, on our own, conduct a 352 balancing in terms of not presenting the goriest or the most graphic, but trying to present the minimum number of photographs to show the maximum number of wounds. And if a picture is in fact worth 1,000 words, as most people seem to think, it's clear that these photographs should be admitted in front of the jury.
All right, let me make a few observations and then we'll take a break so I can review the points and authorities that the people had previously filed in this case. It was a document filed well before jury selection, and at one point we had a hearing that was calendared to deal with this issue, and then it was rescheduled because the witness was unavailable, or for whatever reason, I don't recall at this point why, but we never pursued it. Or the council were going to try to resolve the issue without a hearing. Let me understand the people's position here as far as what is going to be introduced by way of evidence and why you feel it's relevant. Because the first issue is relevance as to whether or not the exhibit that is being offered is going to be relevant to the trial of issues in dispute. And the people have articulated two reasons and then have added another reason in response to the defendant's statements and other perhaps that have not yet been articulated here. One of the reasons that people feel these photographs are relevant is to show the number of shots that were fired. Another reason that people feel that the evidence is relevant, the photographs are relevant, is to show the potential or the actual distance that the shotgun was from the victims at each point when the shots were fired. Then the prosecution also indicates that it will use these photographs to show the elements of malice, premeditation, and deliberation. Other issues that have been referred to, and I don't have a clear feeling of what exactly will be offered, relate to the testimony of Mr. Linhart. Who is he and what is it that he is going to be testifying about?
Mr. Linhart works for the Sheriff's Department. He is in charge of the serology department. He has provided a report very recently that we have given to the defense about where Mr. Menendez was physically located at the time that he received his wounds. In order to do that, he had to look at photographs and was able to describe his findings to us in terms of the photographs. The one photograph from the crime scene, which is now in evidence, is one of the photographs that he's going to be using to talk about where Mr. Menendez was. Mr. Linhart also looked at the various wounds on the decedents. He had both crime scene and autopsy photographs. and is able to describe without great particularity, because there is no weapon recovered in this case, but he describes the nature and somewhat the distance of the wounds, although as I said, he can't get very particular. So he's going to be talking mainly about crime scene things, but the crime scene photographs are so bloody that I think in order to talk about the wounds, that you really need to use the autopsy photographs. One other point that I'd like to make as well is that self-defense appears going to be an issue in this case, and I think the nature and location of the wounds is something that might go to negate the idea of self-defense and the number of the wounds as well.
Well, I was going to get to that, but going back to the crime scene photographs, there have been a series of photographs marked as exhibits, and they go from exhibit 21 through 39. And the people had those marked as exhibits earlier in these proceedings for the purpose of demonstrating the crime scene investigation that was conducted by the police. And although those photographs bear on them the tags that they have been received in evidence, they have not been presented to the jury as yet. Does the prosecution intend to use all of these photographs to illustrate the testimony of any witness, or are some of these photographs that will not be used?
Well, I believe the photographs were brought in redirect of Detective Zoller to explain the collection of evidence. It's my recollection that of all the photographs that are present have been shown to the jury, only one of them contains the victims. All the other photographs, and I think the court even excluded one which contained the collection of evidence right next to Mr. Menendez's right thigh. But all the other photographs, I believe there are a couple that show them in the distance that are just pictures of the room. But as far as direct shots of the victims, there's only one that's been shown to the jury. And as far as the others, those depict the collection of the evidence.
Well, the others haven't even been shown to the jury, and one was only shown at a distance to the jury on a board. It wasn't exactly shown to the jury where they looked at it at close view.
I think I put almost all the photographs up on the board. I recall doing it.
Okay, well, I don't recall that, but.
No, I did do it, but they were difficult to see.
Right. But your proposal is to use all of those photographs in Mr. Linhart's testimony, is that correct?
I don't think we'll need all of them, Your Honor.
And the court did go through that series of photographs and excluded more than one. There were several that the court excluded, and there were two that the defense had objected to that the court did not exclude in that group of exhibits 21 through 39. And the rest of the photographs were not subject to objection by the defense. The rest of that group of photographs anyway. And you have the photographs that have the yellow tags on them that were photographs that the prosecution had offered and the court had sustained a defense objection to them.
The court wish to see those again.
Well, let's just keep them aside so that that's part of our record here, and we'll start marking these things so we have some documentation of what we're doing and have done.
Maybe these three photographs with the yellow tags now would be marked as people's next in order. Just maybe as a court, or not people, I'm sorry, exhibit 72, I think, 74.
Right. Three photographs are exhibit 74, and these photographs are the three photographs that were originally part of those photographs, 21 through 39, that had been offered by the prosecution and objected to by the defense, and the court had sustained a defense objection to those. So they'll be marked collectively as 74. Yes. And going back to the offer of proof here, the court was discussing the testimony of Mr. Linhart and what he would say. Is there a dispute as to where Jose Menendez was situated at the time the shootings occurred?
I I suspect there is, but I don't know that for sure because from the defense opening statement, I wasn't able to determine precisely what they were saying in terms of where he was at the time he was shot. So I think there is a dispute as to what he was doing at the time he was shot.
What he was doing or where he was?
Where he was and what he was doing in that space.
Okay, well, obviously, the defense would have to respond to that. Is there a dispute as to where he was or what he was doing?
Well, as I understand the proposed testimony of Mr. Linhart, and by the way, the defense would have a separate 402 objection as to him since he's identified as a serologist. I don't know whether a serologist.
Well, let's not talk about him other than the fact he's a potential witness that will be subject to another hearing. But let's confine ourselves to this issue here.
I wanted to let the court know that because the court seems to be balancing that in here. But as I understand his testimony, he will
One second. Okay, I'm sorry. Go ahead.
As I understand his testimony, he will say that all of the blood in the case is concentrated in a area in the living room, and that because of the concentration of that blood, both Mary Louise and Jose Menendez must not have moved out of that area. He will also say, as I understand it, that based on some undisclosed analysis on his part, that Jose Menendez was either standing and moving around, in the process of sitting down, in the process of standing up, or even possibly still sitting down when he was shot. His analysis with respect to Mary Louise Menendez is unclear from his report. The only part of any of that testimony that we would dispute is the allegation that Jose Menendez was sitting down when the shots were inflicted, and I'm not even sure he's going to testify to that. The report is unclear, but to the extent he does say that, that would be an issue that would be in dispute. But as to the concentration of the blood and his opinion, if it's admitted that they must have remained in that area, that will not be subject to dispute.
And will the coroner be testifying about whether someone was sitting or standing or moving or anything of that nature?
No.
And regarding the distance, the shots were fired from the victims as far as where the position of the gun was, the barrel of the gun to the victim at the time any shots were fired. Is that in dispute?
No, it's not, Your Honor, and we would be prepared to stipulate that Dr. Golden will testify that his autopsy examination revealed 2 contact wounds. One as to Jose Menendez, that would be to the head wound, and as to Kitty Menendez, a wound to the left cheek. Both of those wounds are identified as contact wounds. We would be willing to stipulate to that fact that those were contact wounds. And it's my understanding of the testimony that all of the other wounds that he describes will be described as non-contact wounds and in the nature of distant wounds. That is not close-range wounds, and that's not going to be subject to dispute either. The location of the wounds and their nature is also not subject to dispute, and we would be willing to stipulate as to that as well.
And as to the issue of self-defense and the people's intended purpose of showing that these shots reflect malice and premeditation and deliberation, what is your response as to why they're not relevant on those issues?
Well, the response is that once Dr. Golden describes those wounds and illustrates the location of those wounds through his contemporaneous diagrams, which he made, that the photographs themselves add nothing to what he's already described and don't in any way address the issue of self-defense once the defense has conceded that the wounds were contact wounds in 2 cases and the rest of the wounds were distant shot wounds.
Aren't the people still entitled to prove this before the trier of fact rather than just rely upon the stipulation? Don't they have a burden of proof?
I think they have a burden of proof, but I think the cases that we cited in the court indicate that the people have no right to offer cumulative evidence, which is prejudicial. And our position is that once Dr. Golden has testified, and given the fact that his testimony would not be in dispute as to the areas I indicated, it would serve no purpose and would be violative of Section 352 to allow them to, in effect, prove up twice the same facts which they can prove once through the testimony of the coroner and his diagrams.
And the defense has also argued that one of the key elements of the defense case, maybe I'm overstating it, but that's my recollection of the opening statement, that the defendants used what is described as overkill, and somehow that is a circumstance that the jury should consider to establish that the defendants were acting with a certain mental state that is consistent with the defense. And aren't these photographs evidence of just that overkill?
Well, the wounds themselves and their location and the number of them are certainly relevant to the issue of overkill. As to whether they're relevant with this witness, Dr. Golden was asked when we interviewed him whether he would give us an opinion as to whether he thought it was overkill or not, and he indicated that that was more outside the realm of forensic pathology and more in the realm of forensic psychology. So I don't think that this witness is going to be offering that opinion, and has indicated himself that he's not qualified to do so. So I don't see how the photographs can be used by Dr. Golden to illustrate the point. And as to our experts can read the autopsy report and see from that report the number of wounds and the nature of those wounds and whether they were contact wounds or not, and can then make an opinion based on the report itself.
Well, just an observation that when the defense uses a phrase such as overkill, which might or might not have some psychiatric or psychological significance, it also has a lay meaning, and one that some people, even people on a jury, might consider evidence and proof of malice, not proof of any state of mind that would constitute a defense, but would constitute an element of malice of forethought, and premeditation and deliberation, or lack of it, depending on circumstance, and the value and weight the trier of fact gives to the evidence. So although the defense has alluded to the phrase overkill and indicates that it intends to use that concept somehow in defense, it also is a concept that can be used by the prosecution to establish the elements of the case that the prosecution seeks to prove to the trier of fact.
Well, my point to the court is we haven't reached the point where the court is allowing or disallowing opinions about overkill. And suppose the court, after hearing the offer of proof on that issue, decides to exclude it for whatever reason, lack of competency, lack of familiarity, and the court, having excluded that testimony, has then already admitted these photos on an issue which there is no defense evidence to rebut. And as I indicated, when we spoke to Dr. Golden about this issue, he said in a tape recording interview, all I can tell you is that it's a subjective interpretation, but I don't think overkill or underkill is really a forensic pathology interpretation. I think that's more of a subjective or psychological interpretation. So again, I don't see how this witness's testimony can serve to rebut any qualified expert testimony the defense may offer on the issue of overkill.
All right, I'm looking at these photographs, and the prosecution indicated one of these was a photograph that you intended to use. That was a crime scene photograph. I can't.
Okay, may I get it?
Yeah, you may look at them and tell me which one is from the crime scene.
Your Honor, while the prosecution is doing that, we filed a response to the prosecution's motion to admit photographs.
Yeah, why don't you bring them on? Okay, we're gonna have some jurors come in, so we'll just take a break here. section, and I now have the memorandum filed by both sides, filed by the prosecution on March the 23rd, and a response by the defense on April the 22nd of this year. First, before you speak, the prosecution has selected one of the photographs from the group that have been presented to me as a photograph from the crime scene. Is that right?
Yes, Your Honor. I also deselected, I should have excluded those before getting into court. I stood up 2 photographs that do show surgical intrusion by the coroner.
You've removed those?
Well, I didn't remove them. I put them are they all,
You've separated them in some fashion?
yes,
Okay, showing probes.
it's of the right arm.
Yes, I see that. Okay. All right, Ms. Abramson, you want to be heard?
Yes, I just wanted to address the issue of how probative these photographs are on the issue of malice. I can envision situations where showing the actual wounds through photographs may have some bearing.
1 second. Can I have the other photographs starting with Exhibit 21, please? Go ahead. Yes.
I can envision situations based on the nature of the weapon used and the method used where photographs would be indicative of malice, because what they would indicate is that the assailant, the actor, could see or understand what he or she was doing during the course of the assaultive conduct. But that isn't true. In this kind of a shooting, we've already had testimony that what happened here was a very rapid series of shotgun firings. That's from Mrs. Crum. And we've also had testimony from one of the police officers that firing off shotguns creates a great deal of smoke. And so there, in the very nature of this, where by anybody's estimate, there's at least 8 rounds fired. One could never say, and since the coroner is going to say that most of the wounds are from a distance, one could never say that in this rapid firing of 2 shotguns in an enclosed space from a distance that the shooters could ever see as it's happening the impact of what they're doing. And therefore, if they can't see it, it doesn't tell us anything about malice during the course of the shooting. Now, the very fact that they shot with shotguns in an enclosed space may say something about malice if the jury rejects the self-defense defense, but that's established simply by testimony that the jury's already heard a great deal of, that there were a number of shots fired that and struck these people who were in a particular space, which we don't dispute. The actual wounds don't add anything to that, as depicted in photographs.
All right, I've looked at the photographs again, 21 through 39, and none of those photographs show the decedents in the crime scene. Was there another photograph that perhaps I'm missing in my review that was a photograph that you referred to,
Number
Mrs.
7.
Bozanich?
Number 7, Your Honor.
All right, let me see number 7 there, please. All right, this is a larger photograph showing both victims at the crime scene and in the position they were situated when the police arrived.
Yes, Your
And
Honor.
that is the only photograph so far that has been received that depicts the victims at the crime scene. Is that correct? And the other photographs are just photographs of items of physical evidence that were accumulated, and photographs showing at a distance Jose Menendez lying on the floor. That's exhibit 21, but at a great distance. Or, I'm sorry, Mary Louise Menendez lying on the floor. All right. And are the people also relying upon the various theories put forward in your moving papers as far as relevance of the various photographs?
Yes, sir.
The only thing I might add is that, in the moving papers were prepared before Mr. Linhart, and Mr. Linhart testified that the position in which Jose Menendez's head is seen in the photograph that the court has, Exhibit 7, is not the position in which the wound was inflicted, because the pooling of the blood indicates that his head was in a more forward position than that which is depicted in the photograph.
And do the people intend to offer additional photographs of the crime scene showing where the victims were and how they were situated?
As to illustrate Mr. Linhart's testimony, what we're gonna offer is a photograph of the sofa without the bodies. And I think we'll need one more photograph that shows Mrs. Menendez lying on the floor to explain some of the splattering. So that would be one more photograph of the victims and one photograph of the couch without the victims in order to illustrate his testimony. And I must say that we could use 10 more to illustrate his testimony, but we have been trying to use the minimal necessary in order to illustrate his point.
Well, again, that's your decision as to what you're offering. I can only deal with the photographs that you're presenting to me that you want to have received regarding the crime scene itself. And as far as the coroner photographs are concerned, I'd have to have a little offer of proof by the prosecution as to each of these as to why they're relevant.
All right, shall I call Dr. Golden?
Well, if you feel that that's the only way you can present that without, if you feel that you can present that orally without his testimony.
Then I think I can. So I think if the court could give me the photographs, then I could mark them. So,
All right.
So this would be a
Certainly.
intelligible discussion. Your Honor, I would like to take this photograph that I've excluded and put it in with Exhibit 74. I think it's 74. No, it's 72 for the ones that I marked in court yesterday, the ones we weren't offering.
72 were the coroner photographs and the Beverly Hills Police Department photographs
Okay.
at the autopsy that you're not offering.
Right, okay, I would like to have those included. Your Honor, as to, I'm gonna start with Mr. Menendez. I'd like to mark this photograph as an exhibit
Starting at 75.
75. Photograph from the crime scene. Your Honor, it takes shotgun wounds to the elbow of Mr. Menendez and also to the forearm of Mr. Menendez. There are no other photographs in existence of the forearm wound. I think counsel would have to agree with that. There are no other photographs of this particular wound. And as to the wound on the elbow, the photograph that I just removed shows surgical intrusion and does not depict the actual pellet entries or exits. I think these are exits. So this particular photograph, 75, you want me to hold it up, Your Honor? Depicts these two separate injuries, which are described by Dr. Golden as being two separate injuries in his autopsy report. The next photograph, photograph 76, depicts the front of Mr. Menendez's right chest. It shows there's one pellet entry wound, which is depicted here, which Dr. Golden can tell the court about. It also shows that there are what appear to be burn marks across the chest of Mr. Menendez, but in addition, there are areas that are not burned. And I think that this is indicative of the fact that at the time this wound was inflicted, that Mr. Menendez was seated. Because I think the analogy would be when you go to get a suntan. If you're seated and the sun burns you, when you stand up, you might have marks on your body from where your flesh was folded together and the sun didn't get at your flesh. And I think that phenomenon is demonstrated in this photograph 76. And so it would aid in the jury's interpretation of the position that Mr. Menendez was in when he's received a wound to his upper arm which traveled across his chest. Exhibit 77 is a wound to Mr. Menendez's left leg. I think this wound is going to be at issue in the case because of my reading of the transcript of an interview that Mr. Burt and Mr. Gillingham had with Dr. Golden in 1990. The wound to Mr. Menendez's left leg, the entry is on the inside, the exit is on the outside. In the crime scene photographs, there is an absence of tissue and shotgun pellets in the position in which the leg is found. I think that this is going to be an issue raised by the defense to demonstrate that Mr. Menendez's leg was not in the position in which it's found at the time that he's shot. And I think that this particular wound demonstrates, is going to demonstrate that point. Lastly, Exhibit 78 is a photograph, and this isn't the last one, this is the second to last one. Exhibit 78 is a photograph of the back of Mr. Menendez's head. This will be testified to as a contact wound by Dr. Golden. And also, this is the entry wound and not an exit wound. Because it is a contact wound, I think that there's something that can be implied about malice. Because it's in the back of his head, I think that there's something that can be implied about self-defense. I think this wound is very critical to an understanding of how this crime occurred. I don't know if there's going to be any dispute that this is an entry wound. Nonetheless, it is, according to the experts, a classic entry wound because of what's called stellate, S-T-E-L-L-A-T-E, tearing, which is caused, according to the experts, by the intrusion of gases into the skull. They become trapped between the skull and the skin and cause an outward explosion, which has this distinctive stellate tearing. Dr. Golden will testify that this is, in fact, a contact wound. Lastly is Exhibit 79, as to Jose Menendez. This particular photograph demonstrates the last of the wounds talked about, and also has a little bit of the chest wound depicted in it. This is a wound to the left elbow. Mr. Linhart will testify that the position of the elbow in the crime scene photograph is inconsistent with where it must have been at the time of the shooting, because the elbow is caught between the sofa and his body, and it's obvious that the elbow would have had to have been in a different position, perhaps elevated at the time of the shooting. In this particular photograph, there is a probe inserted to demonstrate the trajectory, which I think is going to be important in this case. This photograph is also, compared to the other ones, is particularly unbloodied. Now, those are the photographs we would offer to demonstrate the wounds as to Mr. Menendez. Starting with Mrs. Menendez, Exhibit 80 would be the first. And these photographs are not in order of how the coroner will testify, but I'm just taking them in the order in which I have them. Exhibit 80 is a photograph which was taken prior to the autopsy surgeon beginning. And we know that because of the presence of this brownish blanket around the body. What can be seen in photograph 80 are the wounds to her left arm, the wounds to her left breast, wounds to her, and 3 wounds to her leg, which are going to be an issue. One of the wounds to her leg, the entry is on the back of her leg. So this particular photograph, number 80, depicts 5 different wounds, which is why it was chosen, is because it shows that number of wounds. Also, you can tell from the testimony of Mr. Van Horn, he indicated that when you see individual pellets, that indicates some distance in the shooting, because as the pellets spread, they cause a spread pattern. Exhibit 81 is a photograph of Mrs. Menendez's hand. The coroner will testify that this is in fact a defense wound, and although he listed it separately in his report, he said it is affiliated with he believes it is affiliated with one of the 2 wounds to the right side of her face. As a defense wound, I think that this definitely counters any idea of self-defense. There's another photograph here, and I think Mr. Burt has some dispute about it. If I might have a moment to just ask the coroner quickly about one of these wounds before I make an offer.
Hey, Judge, Echo 1 jury.
1 second. Let's first cover up these photographs here, Mr. Burt. Wait. She's right there with.
This is our last one.
Okay, as soon as everyone has settled and everything's covered up, we can have the jury come in. Okay.
The next photograph, Your Honor, would be photograph 82.
Yes.
This is a photograph of the right leg of Mrs. Menendez. It shows actually 4 separate areas of injury to the leg, and it shows the knee bent. This photograph was taken, most likely, Dr. Golden said it was taken before he started the autopsy, but he indicates that there's, to the upper portion of the right thigh, there appears to be a very distinctive looking hole. He said that was not caused by him. So I think that was a question the defense had about this photograph 82. I have 3 more photographs. 83 is a photograph again of Mrs. Menendez's leg. It is a different view of the injuries which occurred in photograph 82. And the last 2 photographs are of Mrs. Menendez's, the last 3 photographs. One photograph here I'll call 84. That photograph shows a close-up of the pellet wound injuries to Mrs. Menendez's left arm. And they are, 84 is a close-up of the wounds which are depicted in 80. 85. The photograph of the head of Mrs. Menendez. Photograph 85 depicts several wounds to Mrs. Menendez. In the photograph, the arm, her right arm is bent. Dr. Golden's report indicates that the 2 wounds here, the right forearm and the right shoulder area, are affiliated with each other, and he actually caused the photograph to be taken in this position to demonstrate that this is 1 wound and not 2. In addition, in the photograph, you can see the portions of her right hand, which are demonstrated in another photograph. You can see the contact wound to her left cheek. You can see the wound to her, there are 2 separate wounds to her face, one of which involves her clavicle and lower right chin area, and another of which involves her right eye and nose. And so there are several different wounds depicted in this one photograph. Lastly, Exhibit 86 is another photograph of Photograph 86 depicts the location of the wound to the clavicle and the right cheek. It also demonstrates the tearing of the shoulder. Dr. Golden will testify that there was 1 more wound to her left side, which I actually think I've neglected to have a picture of. Her left side. It's demonstrated actually in this head wound. You can see below her left ear there's an area of injury which appears to be dark in this photograph, 85. In 86, you can see the tearing of her shoulder. Dr. Golden will testify, his report indicates that the shoulder wound and the wound to her left ear were in fact affiliated. That is, that the pellets traveled across her left shoulder into her area of her left ear. And so even though these are 2 separate wounds, it was his report's indication that these are in fact affiliated because of the presence of birdshot in the shoulder wound and birdshot in the wound to her ear. So I think that we've used the minimal number of photographs in order to depict all of the injuries to Mrs. Menendez. And in addition, there are some other injuries which are not even shown in these photographs, which can be depicted by using the charts. So that would be our offer of proof as to what the photographs show and why they're necessary.
All right. If you wish to respond, Mr. Burt, you may do that. And I'll ask that the clerk give me Exhibit 74. if you want to respond.
Yes, I'll be very brief as soon as I can figure out the numbering system. So just to, first on the Jose Menendez case, 75, the location and the extent of the two injuries depicted in that photograph are not subject to any dispute.
That's
And-
photographs of the arm.
Yeah, I'm holding that up for the court right now. And furthermore, Your Honor, because of the fact that these are crime scene photographs, they are extremely bloody. They do not, as typical coroner photographs show, the nature of those wounds, as much as they show a lot of blood and gore. And the typical coroner photographs have the extraneous blood removed so that the wounds can be clearly depicted. The fact that the people or the coroner or the police department didn't bother to take a proper photograph does not, I think, weigh in the balance here. These photographs do not clearly depict something which, in any event, is not subject to dispute. The defense is willing to stipulate that the wounds depicted in these photographs were inflicted in the way in which Dr. Golden will testify.
The other thing too, Your Honor, is I understood the thrust of Mrs. Kazanich's argument is that the front end, the photograph on the far, rather the wound to the far right of the photograph, to the forearm, was not depicted anywhere else. And if there was an urgent need or any kind of need to demonstrate that wound, the photograph could be cropped and cut out all the extraneous blood and cut out the other wound, which there are other photographs of. So if there was a necessity to show this pellet pattern on the forearm, then the photograph should be cropped to just show it's necessary.
As to photograph number 76 showing the contusion of the chest area, it's our position, there is also a pellet defect which is indicated in the coroner's diagram and in the coroner's visual examination, but the defect is not indicated in these photographs. The only thing these photographs indicate is contusion to the central area of the right chest. And in response to the prosecution's suntan theory, that's a nice theory, but unfortunately the coroner, at least when he spoke to us, said that that wound was caused by, quote, the force of the impact of these other wounds, that is other gunshot wounds to the arm, going through may have caused those abrasions on the chest. In other words, the pass-through gunshot wounds forcing the physical force of the blast, shoving the arm into the chest area and causing that abrasion. That's going to be the testimony, not this suntan theory by the prosecution.
In other words, with our expectations, if there's no testimony that would support the theory that the body is sitting or standing at the time that those abrasions are caused, then those abrasions have answered that question.
As to the photograph number 77, that apparently is being offered in anticipation of the defense argument that because of the nature of that wound, Jose Menendez could not be standing up, or could not be sitting down at the time the wound was inflicted. And it's true that is going to be an argument of the defense, but it's not an argument that can be made from this photograph because the argument depends upon the position of the body at the crime scene. And I'm holding up a photograph for the court, actually two photographs, but the top photograph is a close-up of Jose Menendez's left leg in relation to the couch where he was found. The coroner will testify that this shot to the thigh is from the inner thigh to the outer thigh, that the wound had no pellets inside the wound, and it was a through-and-through injury with matter, blood matter, pellets, and other material being blown out through the outside of the left thigh. So the argument of the defense will be that if that is true, how come there's no matter depicted on the edge of the couch here where you would expect to find matter if he was seated at the time that shot was inflicted? That argument can in no way be made from that photograph because it's a photograph of the left thigh on the autopsy table. As to the photograph number 78, which shows the back of Jose Menendez's head, supposedly that photograph is being shown to illustrate the contact wound. And when we interviewed Dr. Golden, we showed him this photograph, Your Honor, and we asked him, this is from the tape transcript, is that, looking at photograph 421, is that being the contact wound depicted in the photograph right there, which is below? Dr. Golden's answer, I need the diagram of the wound, and I can't seem to find the head diagram. And he then goes on to describe that the contact wound is indicated at the top. I'm pointing to it right now.
Point to the photograph.
Yes, pointing to the photograph at the very top of the diagram. In response, Your Honor, it's our position that we are willing to stipulate that the contact wound was inflicted. He can certainly describe it with reference to his diagram as he did when we interviewed him, and which apparently reflected more accurately the nature of his examination than this photograph did, since he had to refer to the diagram in order to locate it. This photograph is extremely prejudicial and is of no probative value given the defense office stipulating and the fact that the diagram does not clearly indicate a muzzle. The photograph does not clearly indicate a muzzle pattern in any event, and it's not subject to dispute. Again, we're prepared to stipulate it as a contact. The photograph number 79, when we inquired of Dr. Golden as to why that probe was sticking in that wound, he indicated he's not sure what that was intended to illustrate. And it does not appear to be illustrating anything that is subject to dispute. That is clearly an entrance wound. The autopsy protocol indicates that there were no exit wounds associated with that photograph. Dr. Golden will testify that the wounds themselves are scattered shotgun wounds that were probably inflicted from a distance, and that is not subject to dispute. The defense is willing to stipulate to the nature, extent, and location of that wound, depicted in number 79. Percent 81, Your Honor, this is moving on to the Mary Louise Menendez autopsy. The close-up of the hand injury, the coroner has a diagram of the hand injury which sketches out in detail, and I'll provide the diagrams to the court here in a minute, the nature and extent of this wound, and again, it's not a wound that is subject to dispute. The photograph depicted in number 82, in the center of that photograph is a deep gouge wound. At least when we interviewed Dr. Golden, he told me on tape that wound did in fact represent a surgical incision. So I'm not sure what the nature of the evidence is now, but he did clearly identify to us that the wound depicted in the center of this photograph is a surgical cut.
That's 82.
That's number 82. And as to the remainder of the photographs, my only general comment is the nature and extent and location of these wounds are not being disputed by the defense. We're willing to stipulate them. And I wanted to call the court's attention, especially to photograph 85, which I think is particularly gory and inflammatory and something that will inflame the jury on an issue that is not being disputed.
Anything else?
Just to provide to the court the for purposes of comparison and to indicate what the diagram showed. And I'd like these marked, if I could, 2 sets of diagrams that were made by Dr. Golden at the time of the autopsy.
All right, each set relates to one victim, is that correct?
Yeah,
All right, 87 and 88. 87 will be for Jose Menendez, and 88 will be for Mary Louise Menendez.
for the court's convenience, I've arranged these in the order in which the wounds are outlined in the autopsy protocol.
All right, 87 is Jose Menendez, 88 is Mary Louise Menendez. All right. And there are various charts attached there, and they'll be collectively at this point 87 and 88. And I assume there are blow-ups or enlargements of some of these as well.
Yes, it's my understanding that people actually are going to offer these diagrams or
No.
portions.
He's gonna
No, he's gonna recreate them onto, the exhibit.
All right. All right. Anything else?
No, Your Honor, we submit the matter.
People have anything to respond?
No, Your Honor, I would merely, again, direct the court to the appointing authorities which were filed in this case. I think the case law is very clear on that issue.
All right, I have reviewed, again, the points and authorities that were submitted. As I've indicated, they were submitted several months ago. I read them when they were submitted, and I reviewed them again here. And as we all know, and we don't need the points and authorities to tell us, the issues to be resolved in this case deal with, as far as this hearing rather, the issues to be resolved in this hearing deal with relevance and prejudicial effect and the weighing process. The first issue is to determine whether the photographs themselves are relevant. If they're not relevant, then the court doesn't have to engage in any weighing process. So the court first must look at the photographs, and I've done that, and reviewed them to determine whether or not they themselves are relevant evidence in this case to prove any issue in dispute. And the prosecution has presented to the court a theory of why each of the photographs that they have selected are illustrative of evidence in dispute, or will assist the prosecution in proving issues in dispute and elements of the crime. I've heard the response by the defense to each of the photographs, and the defense position that many of the photographs are cumulative and are the exhibits that need not be shown to the jury because there are charts and diagrams and testimony of a witness that can be used in their place. To some extent, that goes to the weighing process more than the relevancy issue, but it does to some extent also relate to whether the photographs themselves are relevant. In reviewing all of the photographs that have been presented to me today, the court finds that the photographs, with the exception of photograph 79, which is a photograph of a wound to an arm with a probe in it, with that photograph, at this point, the prosecution has not met its burden of relevance. I'd have to hear testimony from the coroner in regards to that particular photograph as to why it's relevant to prove an issue in this case. And also photograph 82, which is a photograph showing some wounds to Mrs. Menendez's leg. At this point, the court has not heard a sufficient showing of relevance as far as that photograph. The other photographs that have been marked as exhibits and that the prosecution has analyzed for the court and articulated the people's theory as to why those photographs are relevant. The court has considered the arguments of the defense and the arguments of the prosecution, and I find that those photographs are relevant. They do prove and illustrate the nature of the wounds inflicted in this case, and will assist the jury in understanding the testimony of the medical examiner. They are reasonable representations of the wounds inflicted, and the court finds that they, as I've indicated, will aid the jurors in the determination of facts of this case, and will be helpful to the jury in understanding what happened at the time these shots were fired and the position of the bodies. And also the photographs will be of assistance in the jury's determination as to the elements of malice and premeditation and deliberation, and to some extent also deal with the defense, proffered defense of self-defense that has been put forward by the defense in its opening statement. As to those two photographs, 79 and 82, I'd have to hear further from the witness on that, and that could be done during the course of his testimony without the photographs being shown to the jury. So as far as those photographs are concerned, with the exception of 79 and 82, I find they are relevant and probative. As to the weighing process, whether these photographs are, to use the phrase in most of the appellate opinions, quote, unduly gruesome, end quote, and whether or not their prejudicial effect substantially outweighs the probative value, the relevance of the photographs. The court, again, must look to whether these photographs have relevance and whether the relevance is substantial. And I find that it is as to each of those photographs. As far as the prejudicial effect, no bullet wounds are pleasant and no shotgun wounds are pleasant. That's a given. And no one is saying that any of these photographs depict scenes that one would want to look at if one had a choice. But in a trial such as this, where there are issues in dispute and matters that have to be resolved by the trier of fact, some exhibits that might not be overly pleasant have to be shown to the jury if they have substantial probative value. And looking at these photographs that have been referred to by the prosecution and analyzing them and comparing them to all of the photographs that depict wounds in the coroner's office, the numerous photographs in the coroner's office, and also the crime scene photographs, the court finds that these are not unduly gruesome or unduly prejudicial, that the probative value of all of these photographs substantially outweighs any prejudicial effect. The court notes from the presentation of Mr. Burt that the defense intends to use and offer one or two photographs from the crime scene depicting the position of Jose Menendez on the sofa. That would be in addition to the people's photograph, which depicts both decedents. That's Exhibit 7. And it's quite likely that during the course of the presentation of evidence, either from the medical examiner or from Mr. Linhart, or even during the examination of the defendants in the defense case or other witnesses, other crime scene photographs might become that issue, and the court would then have to deal with those as well, as far as whether the relevancy of the photographs would substantially, and probative value would substantially outweigh any prejudicial effect. The prosecution has been very circumspect in selecting the number of photographs that they are seeking to introduce in this case. Quite frankly, they've selected only one photograph showing the victims at the crime scene, and only one photograph other than the one that was referred to here today of a photograph showing a wound to the victim that had not been taken by the coroner's office. And the prosecution has been very circumspect in not offering at this point any other photographs of the crime scene showing the blood and gore that was present there. And I'm not ruling that those photographs or other photographs of the crime scene would not be admissible. That is something that's not before me at this point. But as to these photographs, with the exception of the two photographs I've enumerated, 79 and 82, they will all be permitted to be used during the examination of the medical examiner. All right, are there any other matters before we proceed with his testimony?
Yes, Your Honor, just a matter of how to display the photographs. The Irwin Golden jury is sitting in the audience section, and we would ask that the photographs that are shown to them be shown at no closer range than the photographs shown on the bulletin board allowing this jury, and in addition to not wanting it right in their face. It's impossible for us to function here with that tripod right behind us, and we're asking that it be placed in front of the bailiff's desk. Moreover, we can't see anything on it when it's right behind us. So both for our knowing what's happening and to put it at an appropriate distance from the jury, we're asking them to be set up in front of the bailiff's desk. So
Well, we'll split the difference and put it halfway between you and the bailiff's desk so that there's
we
some
can see.
room, yeah, so that you'll be able to turn around and look.
Also,
And yes,
I'm sorry, I need Mr. Coriano's help in doing this because
certainly,
because
Yeah.
as the coroner is describing the rooms, I'm going to use these tags to number them, and so that we have duplicates for each jury.
fine.
Okay.
And if Mr. Kuriyama to gain access to the photographs has to walk through the well, you can do that.
Thank you, Your Honor.
All right, anything else before we start?
No.
All right, do you need any time to set up? Are you ready?
Your Honor, I'd like 5 minutes to go.
Okay, we'll take a 5-minute break and we'll resume at 20 minutes to the hour. Let's make it 15 minutes to the hour so that if any jurors want to take a quick break from the jury room, they can do that. And we'll resume at 15 minutes to. In the trial, the defendants are in court with their lawyers. The people are represented and the juries are both present in the courtroom. Good morning to all of you. Good morning. And we're ready to resume with the trial, and the people will call their next witness.
You could call Dr. Golden to the stand.
Just raise your right hand. Your father is ready to say you may be able to cause the whole truth and nothing but the truth.
I do.
Just take the stand and state your name for the record.
Irwin L. Golden, IRWINGOLDEN.
Dr. Golden, what do you do for a living, please?
I'm a deputy medical examiner. I'm employed by the Department of Coroner in Los Angeles County
How long have you been employed by Los Angeles County in this capacity?
since 1980.
Could you please state the training that you had in order to become, in order to have your job?
Yes, as a deputy medical examiner, I'm a doctor of medicine, licensed to practice in California. However, I have advanced training in pathology, which is the scientific aspect of medicine, the laboratory aspect. And I specialize in the performance of autopsies to determine the cause and manner of death. And I've received 5 additional years of training in pathology and forensic pathology, and I'm board certified as a forensic pathologist.
So let me back up. You went to medical school?
Yes,
Where?
went to the University of Illinois College of Medicine.
That was 4 years, correct?
Yes,
And then what did you do after those 4 years?
4 years of pathology residency
And where did you do your 4 years of pathology residency?
at the University of Illinois Hospital.
And then where did you go after that?
Then I had 2 years of military service in the medical corps as a pathologist.
And what branch of the military were you in, sir?
I was in the United States Air Force in a medical corps, so I was 2 years military service.
Okay, now that was after your 4 years of pathology residency, correct?
Yes,
And during the 2 years of your military service, did you perform autopsies?
yes.
Then after your 2 years of military, where did you next go?
Then I was in the practice of pathology, not forensic, just hospital pathology for several years. And then After that, I joined the coroner's office in 1980 as a as a deputy medical examiner.
Could you tell us what a forensic pathologist is and then describe the other kind of pathologists?
A forensic pathologist deals in those matters that come in contact with the law, and basically forensic pathologists specialize in performance of autopsies to determine the cause and manner of death of deceased who fall under various categories that are not natural processes, accidents, suicides, etc.
Are there other kind of pathologists, in other words, people who perform pathology who aren't forensic pathologists?
Yes, the majority of pathologists are hospital pathologists.
And just briefly, what does a hospital pathologist do?
Hospital pathologist, basically the pathologist who runs the laboratory at hospitals and diagnoses biopsies, pap smears, and runs all the he supervises all the laboratory aspects of the hospital. He also performs autopsies on hospital patients.
So some pathologists look at tissue from living people, is that correct?
Yes.
Okay. Now, how many years did you work at this hospital before you joined the coroner's office?
From 72 onward.
So from 1972 until 1980, you were employed there, is that correct? Is that yes? All right.
Yes. Yes.
Dr. Golden, how many autopsies in an average year do you perform?
At the coroner's office?
Yes.
350 to 400.
Would Los Angeles County be considered a busy coroner's office?
Oh, yes.
Prior to your beginning with the coroner's office in 1980, approximately how many other autopsies had you performed?
Well, definitely not as many as here. Would be in the several hundred. Nowhere near in all that time as, let's say, 1 year in Los Angeles.
Right, so that the years that you performed autopsies prior to 1980, you would have performed a few hundred in all those years, and then once you joined the LA County Coroner's Office, you performed on an average between 350 and 400 a year, is that correct?
Yes.
So if you've been with the Coroner's Office almost, let's say 13 years, that's in excess of 5,000 autopsies.
Yes.
All right. On August the 23rd of 1989, at 9:30 in the morning, did you perform an autopsy upon the body of Jose Enrique Menendez?
Yes.
Now, Dr. Golden, during the course of your testimony, are you going to need to refer to your autopsy report in order to refresh your memory as to what you did?
Yes.
All right, and that's what you have in front of you, is that correct?
Yes.
And that autopsy report is an official record of Los Angeles County, is that correct?
Yes.
I take it you've testified before in other courtrooms?
Yes.
Okay, and do you have an independent recollection here today in court as to everything that you did regarding the two autopsies you're about to testify to?
No.
All right. Up on the board, Your Honor, is a diagram. There are two copies of them. I'd like that marked as People's 89. It's the male diagram, please.
Exhibit 89.
Thank you. Dr. Golden, in preparing your report of the autopsy of Mr. Menendez, did you list various shotgun wounds that you observed to his body?
Yes.
And did you give them numbers?
Yes.
And by giving them numbers, did you in any way mean to indicate the sequence in which they were inflicted upon the victim?
No, absolutely not.
Are you able at this point to tell us which wounds occurred prior to which other wounds?
No.
And in regards to Mr. Menendez, how many individual wounds have you documented in your autopsy report?
I documented 6, but I documented 6, not implying the number of separate shots involved.
Okay, so there is a distinction then between the wounds that you're going to describe and the shots inflicted. Is that correct?
Yes,
All right, so what you're going to tell us about then are 6 different areas of wounding in addition to some other findings that you made. Is that correct?
yes,
All right, and I believe that you indicated in your report the first wound that you documented was wound number 1 to the back of the head. Is that correct?
yes.
May I approach, please, Your Honor? Now, the photograph has been marked. It is Exhibit 78. Dr. Golden, I'd like to ask you if you recognize the wound which is depicted in photograph 78.
Yes,
And is that the wound that you refer to in your autopsy report as wound number 1?
yes.
Right. And could you describe for us what is depicted in this photograph and what that wound is, please?
Well, it shows the back of the head or scalp, which has been shaved by the coroner's photographer to show the shotgun entrance wound or hole on the back of the head.
Your Honor, this time I'm going to place a tag with the number 1 next to the wound, not on it, to depict that as wound number 1 for purposes of reference. And I'm also going to put a tag with a 1 on it on the diagram 89, Your Honor, near the area where the wound was. And I'm going to put this photograph on the board. Now, Dr. Golden, from where you're seated, can you see this photograph?
Yes,
Okay. Would you please describe for us, well, first of all, as an autopsy surgeon, can you distinguish the difference between entrance wounds and exit wounds?
that's part of the job. Yes,
And the wound which is depicted in the photograph on the board, which we are going to call wound number 1, is that an entrance wound or an exit wound?
no, that's an entrance wound.
All right. And could you tell us why that is an entrance wound?
Well, it has all the characteristic appearances of an entrance wound.
And what are the characteristic appearances of an entrance wound to the back of the head?
Well, if it's a so-called contact wound, that is the muzzle of the weapon, in this case the shotgun, is placed directly in contact with the body, in this case the scalp. And here this would mean the entire load.
What do you mean by the load?
Well, the load of the shotgun shell, that would include the pellets and any wadding material that's packed into the shell to separate the pellets, the individual pellets from the powder charge. So that was that entered the head, the inside of the head, and I recovered pellets along with the wadding.
All right. Now, when you talk about the wadding, are you referring to a portion of the inside of the shotgun shell?
Yes,
And you recovered wadding from this wound, is that correct?
yes.
Now, is there anything about the tearing to the back of the scalp, which is depicted in the photograph on the board, which indicates to you that this is, in fact, an entrance wound?
Yes, two things. The scalp is torn, so those lines extending out from the hole indicate tearing of the scalp. That would be caused by the explosive charge, the gas coming out of the muzzle of the shotgun enters the scalp and then lifts the scalp up and tears it. So that's characteristic of an entrance wound.
And let me interrupt for a moment. Is that called something? Is there a word for that? For the tear, that pattern that you see on the back of the head? Is the word stellate something used in your report to describe the tearing?
Yes.
So I believe you've indicated then that this is in fact an entrance wound to the back of the head of the decedent, is that correct?
Yes.
And I believe in describing it, you also said it was a contact wound. Could you tell us what a contact wound is?
The muzzle of the weapon, in this case the shotgun, is placed in contact with the body, in this case the scalp.
And when you say contact, are you talking of any distance between the end of the gun and the skin? Or are you talking about the gun being placed right up against the skin?
Well, in this case, it's placed against, it would be placed against the hair, which is pressed against the skin, but that's a contact wound.
And now, why do you say this is a contact wound?
Well, it has all the appearances, a large defect, these radiating tears, marked destruction of the bone inside the head. Plus, I found black deposit of soot on fragments of bone, which is characteristic of a contact wound.
Now, during the course of your testimony, I think you're going to be making reference to the term soot and also to the term stippling. Could you tell the jury what soot and stippling are?
Soot or smoke or powder gas is what comes out of the muzzle end of a gun or rifle when a shot is fired. That's the part of the charge that explodes and comes out of the muzzle end of the gun along with the bullet or the shotgun load. It's part of the small explosive process whenever a round is discharged. So that will come out of the muzzle end in addition to the bullet or charge. Stippling, gunpowder stippling, sometimes known as powder burns, refers to the small particles of gunpowder that come out of the muzzle end of the gun, also along with the bullet whenever a shot is fired.
Now, I believe you've indicated then that you saw soot inside of the head. Is that correct?
Yes.
Okay. Did you see any soot outside?
No.
Okay. Now, why? What does that mean to you?
Then, if there's a tight contact or seal between the muzzle end of the gun and the body, then there won't be soot on the outside. It will enter inside. If the muzzle is off by a small distance or several inches, then the soot will make a ring or a ring or a circle around the outside of the hole. That would make it a close range wound.
Okay. So if the soot is inside of the wound, then that would lead you to believe that it was a contact wound. And if it's outside the wound, that would lead you to believe that the muzzle was some distance from the wound. Is that correct?
Yes, roughly. If it's only on the inside without being on the outside, then it would be a contact wound. If it's outside only, it would be close range. If it's outside and inside, it could be very close, near contact.
Now, we're using terms in your testimony like close and very close without being precise and using inches and feet. Is there a reason for that?
Yes, there is.
What is the reason?
The only way to get an exact distance or range of fire, particularly with a shotgun, is to fire the actual weapon with the ammunition that was used. That's the only way a ballistics or firearm specialist can tell you the exact distance. There are too many variables in load, length of barrel, charge, ammunition used to be precise. A forensic pathologist can classify them only in range approximations: contact, close, or distant.
All right. So when you're talking about close, well, contact, I think you've described close. What are you referring to? Inches, feet? Just can you give us a range?
In a shotgun wound, close is meant to imply that the shot pellets are in one tight group and enter the body in one tight cluster. They haven't separated yet. That's generally what can be meant as close. There hasn't been any spread of the pellets, so that's variable. It depends on the barrel length and the ammunition used. When it gets distance, the pellet starts separating, and again that could be variable. Normally, with the usual barrel length shotgun, it's taken to be from 5 or 6 feet. The pellet starts spreading out and giving an individual pattern. And with the sawed-off shotgun, it'll be closer. It could be 3 to 4 feet. So that's generally what we mean by close. One hole entering, one volley of shot, tight cluster emptying, producing just one defect.
Now, referring back to this wound, which we're calling number 1, I believe you indicated you recovered some wadding and you also recovered some pellets. Do you remember approximately how many pellets you recovered?
Yes, 12.
And did you find anything that you associated with exit wounds in regards to this wound number 1?
I found 2 small tears compatible with exit wound, meaning where pellet or pellets may have exited or left the body.
And where did you find those tears, please?
One was on the right ear. Another was on the right temple.
I'm going to refer now to the diagram, which is 89. The second paper that appears to be a side view, and I believe you indicated in your testimony that there were 2 wounds. I think you said right ear. Could you just come and make 2 dots on the head? And then I'll reproduce them on the other one. 2 dots on this diagram. Your Honor, I will try to reproduce that as accurately as possible. Now, with this particular wound, would you have expected to find more exits?
No.
Okay, why?
Well, many times a contact wound of the head does not produce many individual exit wounds. Many times there's a large defect, and a lot of the pellets may just exit through one large defect, or I guess you could say hole in the skull.
Does the presence of the skull hold in any of the pellets?
Yes, many times it does, yes.
Now, do you have an opinion as to how this wound number 1 contributed to the death of Mr. Menendez?
Well,
What is your opinion about this specific wound?
well, it's a fatal wound with massive injury to the skull and brain.
Now, would this wound have been classified as an immediately fatal wound?
It appears to be immediately or a rapidly fatal wound, yes. There's no way a forensic pathologist can tell you exactly how long survival is, only in a few instances only.
Well, in terms of immediately fatal, if that were your diagnosis, and that's what you're saying. Is
Or a rapidly fatal wound.
Well, how long would it take before the heart would stop pumping? Would it be less than 30 seconds, less than a minute? Or do you...
Again, that's something that I can't unequivocally tell you, because there are always cases of remarkable or unusual survival with very severe wounds that can't always be accounted for. And I mean, we have evidence that in many cases or reports. So there's no unequivocal way of saying exactly how long that would take.
If a person has sustained a wound like that, they would not be able to move after that wound. Is that correct?
Yeah, it appeared by all appearances with the multiple skull fractures and the brain injury, yes, it appears to be a by all accounts, a rapidly fatal wound.
Moving now to what you've described as wound number 2, right? In your report. Could you refer to that part of your report, please?
Yes?
Okay, could you please describe for us, and may I approach again, please, Your Honor, where wound number 2 was?
Well, the wound number 2 group was on the upper arm and the right forearm.
Now, referring to diagram 89, could you tell me, well, is it better to use the back view or the front view to illustrate wound number 2 with these dots that I'm going to use?
The front view.
All right, and wound number 2, what you referred to now, could you describe it for us in words?
Well, wound number 2 is what I've already classified as a distance shot. There was no single hole or entrance. It's a number of individual pellet defects.
And
Six on the 6 in number on the upper part of the right arm, above the elbow region, and that is a distance shot, characterized as a distance shotgun wound.
all right, would you please come to the diagram 89 and show us on the diagram where wound number 2 was? Now, you drew diagrams of each of the wounds, is that correct?
Yes?
All right, is that part of what you're referring to in formulating Exhibit 89?
Yes.
Could you show us on this diagram where wound number 2 is? Just point it at, not having to illustrate it. All right, now, where wound number 2 is both above and below, is that correct?
Yes.
All right, so I'm gonna put 2 stickers, one above and one below. That's wound number 2. And could you please tell me where the wound entered? In other words, did it enter the front of the arm or the back of the arm?
Well, it would be the front. What I would refer to anatomically as anterior, but I guess it could be considered the front of the arm,
All right, so,
in front of the elbow region.
all right, so anterior then means like the front of my arm where I would bend it, and what do you call the back of my arm?
That's the posterior is anatomically what's referred to as the back of the arm.
All right, so the wound number 2 then, the entrance was to the front of the arm? Is
Yes.
that correct? And the exit would have been to the back of the arm, is that correct?
I don't believe I've described any exit wounds with this one. I recovered some pellets and no wadding.
And do you remember about how many pellets you recovered from wound number 2?
Yes, all I was able to recover were 2 pellets from the wound path in this case.
Did you find any soot deposit affiliated with wound number 2?
No, this was a distant shot or a distant type of shotgun wound.
And I believe you indicated there were 6 individual defects, indicating that there were 6 individual little holes, which would relate to 6 little pellets. Is that correct?
Yes.
All right. What was your opinion as to what kind of damage this wound did to the decedent? Would that wound have caused him to die if it was the only wound?
No.
Would it have incapacitated him?
Actually, it didn't strike bone. It appears. Well, correction. I'm sorry about that. I wasn't reading farther down. This wound did cause a fracture of the upper part of the right arm, the right humerus. So in that instance, it would be an incapacitating wound because of the complete fracture of the right arm or right humerus.
And moving on then to wound number 3, could you please describe for us verbally, and then we'll go to the chart, what wound number 3 is, please?
Well, that group was on the right upper arm, but on the back, actually, it's on the precisely, it's on the back of the right forearm.
All right, by the forearm, do you mean below the elbow?
Yes.
All right, and that's wound number 3, and I'm going to put it on the back portion of this diagram 89. And I'm also going to show you a photograph, and I'd like to ask you if in the photograph you can identify wound number 3 for us.
Yes.
Okay, where is wound number 3?
It's on the back of the right forearm.
Okay, is that here, Dr. Golden?
Yes.
All
Can I
right.
see what you're pointing to?
Yes, I'm sorry, right here. I'm going to put a number 3 next to it.
Thank you.
What exhibit is that?
I'm sorry, Your Honor. This is Exhibit 75, which has been marked, and I'll put it above the wound. So I believe then, it's your testimony that when you say the wound is to the back of the forearm, does that mean that the entry is to the back of the arm?
Yes.
Now, I believe that you indicated when I asked you about wound number 2 that you use terms like anterior and posterior. Is one of the reasons you use those terms versus back and front because you don't know what position the arm was in when it was shot? Is that correct?
Yes.
All right. For our purposes of having not been to medical school, then wound number 3 was to the back of this arm. Is that correct?
Yes.
But it in no way means to indicate that the arm was in any particular position, except that the bullets entered through the back of the arm. Is that correct?
Yes.
Now, did you also describe a wound as wound number 4?
Yes.
And what is wound number 4, please?
These were shotgun pellet wounds. Again, distant type of wound of the left elbow with recovery of multiple lead pellets.
I believe you indicated in your report that there were 9 individual pellet wounds in the area of the left elbow, of which 5 you recovered.
Yes.
And were you able to determine where the entry was? In other words, was the entry to the back of the arm, the back of the elbow?
The elbow, by definition, is the back.
All right. Well, is there a medical term for this?
That's the antecubital fossa that you're pointing to.
Okay, so it's the inside of my elbow, right?
Yes.
Okay. May I approach, please, Your Honor?
Yeah.
On wound number 4, I believe you've indicated would have been here on the left elbow. Is that correct?
Yes.
Okay. Do you have that, Mr. Fairhaven? This wound number 4 to the back of the elbow, do you have an opinion as to whether or not that would have been fatal?
Ordinarily, this is not a fatal wound. It did not strike any vital organs or structures.
Moving ahead now to wound number 5. Could you please describe verbally for us wound number 5?
That was a wound of the left thigh without recovery of any without a recovery of any projectiles.
Now, where did the wound enter and where did it exit? Where was the
It
entry?
was located on the lower left thigh, sort of on the inside of the lower left thigh.
Your Honor, I'm going to place a 5 then, next to the inside of the left thigh on this diagram 89. And I have a photograph here, which is Exhibit 77. I'd like to ask you if this depicts the wound that we've been talking about, wound number 5.
Yes.
And I'm going to mark the photograph with a 5 placed just on the photograph near the wound. This wound number 5, I believe that you indicated that the entry was on the inside, what we would call the inside of the thigh, and the exit was on the outside portion of the thigh. Is that correct?
Yes.
All right. And could you give me some more detail about this wound, please?
This wound had a single large hole or defect, but it appeared that there was beginning separation of the shot, because I saw 2 what we call satellite pellet defects. Satellite meaning separate holes away from the main hole. That indicates it's beginning separation. So again, I can't give you the precise distance. It would depend on the shotgun barrel length and the shotgun shell used. Normally, with the usual shotgun that's not sawed off, separation begins at around 5 or 6 feet. That's the estimate. Somewhere in that vicinity, but there's no way of telling exactly. So this is, it's obviously not, it's not a contact or a close range wound. It's beginning separation. So it may be, if my conditions are satisfied, the usual type of barrel length be somewhere between 5 or 6 feet.
Now, did you notice any satellite defects in relationship to the entry wound?
Yes.
I believe your report indicated 2?
Yes.
And that the satellite means that some of the pellets have strayed from the central core and make individual entry. Is that correct?
Yes.
Were you able to recover any of the pellets from this wound number 5?
No, it appears to have gone through the leg and exited on the outside of the thigh, opposite the entrance wound. I didn't recover anything on that.
And in addition to your opinion that this was a distance wound, then there was no soot or stippling. Is that correct? As to this wound?
That's correct.
And what did this wound do to the leg? What kind of damage did it do? May I approach you, and I think I put that number 5 on exhibit 89.
Well,
Could you please tell us what damage it did?
it caused a complete fracture of the left femur or thigh bone, and it was completely separated. The bone ends were separated, so it was completely mobile.
Would that cause a person to become incapacitated?
Yes.
So you wouldn't be able to walk on that leg, is that correct?
Yes.
Would that wound have been fatal if there had been no other wounds?
I wouldn't say it's an immediately fatal wound. It's just incapacitating.
In addition to the wounds that we've described, did you also find any kind of abrasion to the chest of Mr. Menendez?
Yes.
Right. And I think for our purposes, we're going to refer this to this as number 6. Could you describe for us what kind of abrasions you found to the chest of Mr. Menendez?
Well, on the front of the chest, to the right of the midline or sternum or breastbone, there were a number of abrasions or scratches.
Right. Your Honor, for the record, I'm going to place a number 6 on 89 in the area that's just been described, in the general area that's just been described. And I have here a photograph which has been marked as 76. I'm also going to place a red dot next to a ruler that's on this photograph 76. Dr. Golden, showing you photograph 76. Does that depict the injuries you just described, and which we're going to refer to as number 6?
Yes.
Placing this now on the board. Dr. Golden, could you tell us what this is, please?
The entire photo?
Yes, what are these injuries depicted in the photograph?
Well, as you said, there are multiple abrasions or rubs of the skin, and there's also one pellet defect also on the photograph.
Now, could you, for those who didn't go to medical school, could you tell us what an abrasion is? What is your definition of an abrasion?
Abrasion is a blunt injury caused by scraping of the skin on a rough surface. It would ordinarily be called a scratch or a rub or a burn, where the skin is broken but not the deeper tissues.
All right, so that would be like skinning your knee or something would be an abrasion?
Yes.
Okay. And I believe you indicated that there was a pellet defect contained within this area called number 6.
Yes.
Okay. And could you tell in which direction the pellet was traveling?
Well, it just, this was a superficial pellet wound. It went into the skin and struck the sternum or breastbone. So,
Can you see it in the photograph, that individual pellet wound you've described?
I believe so. It's sort of dark.
Okay, could you maybe come here? I'll bring the photograph and circle it, please. Could you circle that for me? Do you see it in the photograph? And could you also circle it on this photograph too? Thank you. What caused this? Can you tell what caused wound number 6?
Well, I know it caused the shotgun pellet wound because it was recovered from the bone.
As far as the other reddish portion of this,
Yeah, you want to know about the abrasions?
yes, could you tell us about the abrasion, please?
They're probably related to the shotgun wound.
And which shotgun wound are you referring to?
Probably the one of the right arm, the right arm and forearm, which we discussed earlier.
Was that wound number 2?
Yes.
And in that photograph, it appears that there is some area that is not braided. I'm sorry, Mr. Runner, a question?
I can't see where he circled that.
Oh, okay, well,
All right, no, perhaps you can do it again with something darker.
in the photograph, I've now marked it with a thicker black pen. Dr. Golden, in this
What
photograph,
exhibit is that for?
I'm sorry, I think it's 76. Yes, it's 76. Dr. Golden, in exhibit 76, there appears to be portions that are, I guess, striped, or I don't know if there's a medical term, but you see here right next to the circle, there's an area here that's white. Can you explain what would cause that to be white and the other portions one are red?
Well, the white area is normal skin that's not abraded or scraped.
All right, so that skin was not then exposed to whatever abraded the other skin. Would that be correct?
Yes.
In addition to the 6 wounds that we've discussed, did you find anything on the right lower thigh of Mr. Menendez? I believe you need to refer back to the beginning of your report for that.
Yes, I referred to minor abrasions on the right lower thigh.
And I believe you described it in your report as being annular. Is that correct?
Yes,
Okay, what is that in English?
round.
And what can you tell us more specifically about these abrasions on the right lower thigh?
Not much.
Were you able to tell if these
They were nondescript, and I didn't see any particular pattern. All I can say is that in shotgun wounds, particularly distant wounds, there are abrasions caused by wad marks. That is when the wadding, whether it's felt or cardboard or plastic, strikes the skin but doesn't embed in the skin. And in shotgun wounds, particularly distant wounds, very often there are wad marks or wad abrasions, which just indicate that it's a distant shot, and the wad strikes the skin, causing the mark. So that's not uncommon in shotgun wounding to have additional abrasions, not pellet wounds.
But abrasions similar in color then to what is exhibited in photograph 76?
Yes, many times, yes.
Now, I'm going to put just a red dot that's unnumbered here on the right side to indicate that separate area, because that is also the last area we'll be discussing. Were you able to tell the age of these abrasions, how long they've been there?
All I can say is they appear to be recent, all of the same age.
And by the same age, are you talking about the same age as the other injuries that you've already described in your testimony?
Yes.
Now, after examining Mr. Menendez, are you, as part of your job, to determine the cause of death as to an individual? Is that
Yes.
okay, and what are your choices as a coroner? What are the things that you can say about the cause of death?
I'm not sure about.
Well, can you say it's suicide?
Well, that's the mode.
Okay, I'm sorry. You're right. As to cause of death, what was the cause of death as to Mr. Menendez?
Well, the cause of death was multiple shotgun wounds.
And wound number 1, the one to the head, is the one that would have been immediately, or you used another word, fatal. Rapidly fatal.
Yes.
And the mode of death, which is what I was referring to. You have choices as to mode of death as a coroner, is that correct?
Yes.
And what are your choices?
Homicide, accident, suicide, natural, or undetermined.
And what was your determination as to Mr. Menendez as to the mode of death?
Homicide.
May I have a moment, please, to check my notes, Your Honor? So as to Mr. Menendez, there was one contact wound, which was to the back of the head. Is that correct?
Yes.
In addition, do you cause tissue and blood samples to be taken from the decedents in order to determine if there was any kind of drugs or alcohol present?
Yes.
And as regards Mr. Menendez, did he in fact have any kind of alcohol present at the time that his blood or tissue was tested?
Yes. Yes.
And what was the blood alcohol?
Decimal point 0.04%.
Now, 0.04, well, you're aware of the drunk driving laws say that a person is legally drunk at 0.08. Is that correct?
Yes.
So this is half of what that is. Is that correct?
Yes.
Now, in determining blood alcohol readings, is it fair to say that you can't determine if the person had you can't determine at what time the person drank the alcohol based upon the reading. Is that correct?
Yes?
Another thing I wanted to ask you about is time of death. I know sometimes people ask you about time of death. Can you tell us how precise you can be in terms of these particular autopsies as to time of death?
Not very precise.
What are some of the factors that contribute to how you determine time of death?
Well, the internal body temperature is taken in these. The coroner's office takes the liver temperature. That's the internal body temperature to see determine possible rate of cooling of the body and the degree of stiffening or rigor mortis or rigor mortis are used by medical examiners to try to give an estimate or range.
Is the temperature in which the body is found at, that is the ambient air temperature, is that a factor in determining how fast the body cools?
Yes, there are many factors, and that's why it's imprecise.
Are you able in this particular case as to Mr. Menendez to give us with any precision the time of death?
No, especially in this case, there was a long delay in the coroner's investigation, not the police, the coroner's investigator taking the body temperature. So the estimates would be too imprecise for our purposes.
Referring now to the autopsy performed on Mary Louise Menendez. Again, on August the 23rd of 1989, did you perform an autopsy on a woman, Mary Louise Menendez?
Yes,
And I believe in your report you indicated that you had identified 10 separate areas of wounding. Is that correct?
yes,
Okay. And again, as with Mr. Menendez, the order of the numbering is not your opinion on the order in which the wounds was inflicted. Is that correct?
that's correct.
Now, referring to Mrs. Menendez, starting with wound number 1, could you describe for us where wound number 1 was located, please?
Shotgun wound number 1 of the head, particularly, was on the left cheek.
What can you tell us about this wound, please?
It was a contact wound with soot or smoke deposit in the deeper tissues on the pathway. And I did recover some plastic wadding in this case.
Your Honor, may I approach the witness?
Yes.
Your Honor, I have here another diagram. I'd like to mark it, please, as Exhibit 90.
Oh, for sure.
Dr. Golden, I'm going to show you a photograph which has been marked. Is photograph 85. Photograph 85, can you see wound number 1 in this photograph?
Yes,
And I believe you described it to being as being to the left cheek, is that correct?
yes,
Could you point at that for me, please? All right, Your Honor, he's identified a wound to the left cheek. I will mark this with a green dot as wound number 1, and I'll place it next to the wound. Now, I believe you indicated that was a contact wound and you saw soot inside of the wound. Did you see any soot on the outside of the wound?
no, I did not.
I believe you indicated you recovered some pellets. Is
Yep.
that correct?
I recovered, as I didn't the first time, there were bird shot pellets and a plastic wadding.
And now, are birdshot pellets different in size from the other kind of pellets that you recovered from Mr. Menendez?
To my Naked eye examination, yes, birdshot are the smallest type of pellets you can recover.
Do you have an opinion as to what kind of damage this wound number 1 would have done?
Well, there were extensive fractures of the jaw, and well, there were multiple fractures of the skull associated with this, along with the problem that there were other gunshot wounds to the head. So when they intersect like this, it's impossible to say exactly what caused, which wound caused which fracture, because their pathways are too close together. The one I'm going to describe subsequently, too, is also into the head on the other side.
All right, let's get on then to the next wound, which is wound number 2 in your report. Where was wound number 2, please? As for the record, I'm going to put a 1 up next to the left cheek on diagram 19. I'm going to move this one over so it doesn't obstruct all the others. Where was wound number 2?
The one I grouped as wound number 2 involved the right cheek, the eye, the nose, and the nose, and a portion of the left cheek.
Could you please leave the witness stand and just point out to us what grouping you're talking about as wound number 2 in this photograph?
I'm referring to this cluster here.
All right, and
The forehead, the eye region, the nose, and the cheek.
including the upper lip, I think. Is that
Yes.
correct? Right, Your Honor, I'm going to put a this one on both the diagram and the photograph, which is Exhibit 85. Now, the kind of shot or the kind of pellets that was used in wound number 2, was that different from the kind of shot from wound number 1?
They were larger than the ones in wound number 1. Wound number 1 I described as the tiny ones, birdshot. These appeared to be larger.
Did you recover any pellets from this wound?
Yes.
Do you know exactly how many pellets you recovered?
No, just as best as I can do, a representative sample.
And did you notice, how many individual pellet wound defects did you notice as to wound number 2?
Approximately 10.
And do you have an opinion as to what kind of damage this would have done? In other words, would it have been fatal? Would this have been survivable?
This produced multiple fractures of the face and probably of the skull. Again, it appeared to intersect the shotgun wound that I described just before this, number 1. They're both going and meeting in the same area. One is the left side, the other is the right side. They appear to be meeting, so it's impossible to tell which one caused which fractures. But ordinarily, this would be considered a fatal wound causing damage to the skull and face.
Moving now to wound number 3 in your report. Could you describe for us where wound number 3 was located?
This one involved the head, the right side of the jaw, and the right clavicle or collarbone. And I've already indicated that it's in proximity to wound number 2, so it's not unequivocal that it's separate. As a matter of fact, it could be related or the same shot as number 2.
All right, so I have here another photograph, which is photograph 86. And I believe when you're talking about the clavicle, do you mean the collarbone right here? Is that
Yes.
correct? All right, photograph 86, I'm going to mark next to the clavicle with a green tag number 3. Now, in addition to the damage to the collarbone, there's damage to the lower jaw in this photograph. Is that damage to the lower right jaw, in your opinion, affiliated with the wound to the collarbone?
It may be if with the tilting of the head to the right, it may be related.
And I'm also going to place a tag number 3 then in the collarbone area of this diagram number 90. Did you see any soot or stippling after this wound, which we're going to call wound number 3?
No, this is classified as a distance shot, individual pellet defects. So it's classified in the distant range, and there is no soot or smoke or gunpowder associated with these wounds.
How many individual pellet wounds did you note as they pertain to wound number 3?
Approximately 10.
Did you also recover some of the projectiles, some of the little pellets?
Yes.
Do you know about how many you recovered?
No, they were lead pellets, again, similar to those in 2, larger than birdshot, and I took a representative sample and submitted it as evidence.
Now we're going to move to wound number 4. Could you describe for us where wound number 4 was located?
What I call wound number 4 is on the left side of the head and left ear, going to the back of the neck. And on this wound was associated with birdshot. In other words, the tiny pellets that I described for shotgun wound number 1. And this again was a distant shot, multiple individual pellet defects indicating spread. So this is in the distant range, but with the birdshot.
So then you described 2 birdshot wounds. One was to the left cheek and one was to the left, near the left ear. Is that correct?
Yes.
And here in photograph 85, which already has 2 dots on it, you can see on the left cheek some blood and also some darkness. Is this the wound that you're talking about, which is wound number 4?
No. Wound number 4 is behind the left ear.
All right. We don't have a photograph of that here. Let me continue on and ask you some more questions. There's damage to the left shoulder shown in this photograph, whose number I've forgotten. In photograph 86, there's damage to the left shoulder. Could you tell me if the damage to the left shoulder was affiliated with this wound, which you're calling number 4, which was behind the left ear? You need a moment to go through your report.
Yes, I do.
While he's doing that, Your Honor, may we approach with the reporter, please?
Yes.
Dr. Golden, the injury to the left shoulder, which is shown in photograph 86, was that affiliated with the injury to the left ear?
It appears entirely consistent with it. Birdshot. It was a distance shot with birdshot pellets recovered, and by appropriate, I guess I could say, manipulation of the left shoulder or tilting of the head, it could be 1 shotgun blast, not 2.
So your testimony then is that the injury to the left ear and the shoulder both contain birdshot, is that correct?
Yes,
And that the injury to the left shoulder is reasonably affiliated with the injury to the ear, is that correct?
Reasonably, or it's consistent.
So that would have been,
They're close to one another, yes.
and that was from a distance as opposed to the contact wound on the left cheek, is that correct?
Yes, this was a distant shot striking two different areas, the left shoulder and the left side of the head.
Do you have an opinion as to wound number 4? In other words, would that have been immediately fatal?
Not ordinarily, no. It did not go into the head. It was basically into the skin and soft tissue, and ordinarily this is not be considered an immediately fatal wound.
And let's continue on now to wound number 5. Could you describe to me where wound number 5 is located?
This, what I call number 5 is on the right upper arm.
In addition, is there another wound to the forearm that you've classified in this group of wounds as number 5?
Yeah, oh, yes, okay. The one I classified number 5 consisted of two groups or clusters, one on the right upper arm front and one on the forearm.
In the photograph, which is photograph 85, then are you talking about the wound to the right forearm and the right, near the right shoulder here?
Yes,
Arm is bent. Now, did you bend this arm for purposes of demonstration in the photograph?
yes,
Right, Your Honor, I'm going to put a tag number 5 then, right here in the crook of the arm to demonstrate this grouping, and also put it on diagram 90 as well, near the elbow, or the inside of the elbow. So was it your opinion then that these two wounds on these two separate parts of her body are most likely affiliated with one shotgun blast?
most likely if the arm is bent in the appropriate way, it appears or is entirely consistent with being caused by one shotgun wound.
Now, did you recover or did you notice any pellets as to this particular injury, wound number 5?
I did recover multiple lead pellets and submitted them as evidence. No wadding.
And were the pellets consistent with the bird shot, or were they larger than bird shot?
Well, I described them as pellets, not bird shots. So
So they were of the larger variety, is that correct?
yes, yes, that's correct.
And what was your opinion as to whether or not this wound would have been fatal, wound number 5?
Non-fatal, fracture of the bones of the right arm. It would be considered an incapacitating wound, but not immediately fatal wound.
Now, going on to wound number 6, would you describe for us what wound number 6 is, please?
The shotgun wound of the left side of the chest.
Did you notice individual pellet entry wounds?
Yeah.
To this?
Yes, this is again a so-called distant shot with multiple individual pellet wounds. I counted 16 over the left side of the chest and the left breast region. Again, classified as a distant shotgun wound.
I have here a photograph, Your Honor, photograph 80, which has been marked. I'd like to show it to the witnesses. Does this photograph show the left side of Mrs. Menendez's body before you began your autopsy?
Yes,
And the wound that you've described, in which we're calling wound number 6, is that depicted here in this photograph?
yes,
Okay. To the left breast, there appear to be a number of pellet wounds. In addition, to the left forearm, there appears to be a number of pellet wounds. Is that correct?
yes,
All right. In your opinion, would the wounds to the left forearm be consistent with the wounds to the left breast, and that it's consistent in terms of one shot?
It's possible, yes.
Placing this on the board, then I'm going to place a sticker in, again, next to this wound, sticker number 6. I photographed in the crook of the left arm, and also on the diagram exhibit 90, place this next to the left breast of wound 6. Now, I believe you've indicated then that this was a distance wound, is that correct?
Yes,
And one of the reasons is because you can see individual pellet holes, meaning that the shotgun load had already started to spread when it hit the decedent.
yes.
Do you have an opinion as to whether or not this particular wound would have been fatal?
Well, in this wound, there was entrance into the rib cage and into the chest, and I did find blood in the chest, and there were individual pellet wounds of the left lung causing bleeding into the chest. So this would be considered a fatal wound because of perforation of the left lung and bleeding into the left side of the chest.
I take it then with this wound number 6, you didn't see any sort of stippling associated with a closer wound, is that correct?
No, it's no soot or sibling. It's a distant range wound.
Your Honor, would this be an appropriate time to break?
All right, we'll take our noon recess. We'll resume at 1:30. Don't discuss this case with anyone. Don't form any final opinions about it. We'll resume at 1:30. Outside presence of the jury, the defendants are in court with their lawyers, and the people are represented. The juries are not present. And counsel want to speak to the court on a subject relating to the photographs. I have been presented with duplicate photographs which have been marked as Exhibit 91.
With court permission, may those be so marked, and I have cropped them at the request of the defense. Those are to show the wound which we call number 4 as to this Menendez.
And what is it that you wanted to discuss?
I think the defense has an objection.
Judge, we still raise the same objection we've raised to the other photographs, and I don't need to repeat those arguments, but we would submit the same objection.
And this is a photograph depicting the wound that was being discussed and described by Dr. Golden, for which there was not a photograph marked. That was wound number 4, is that correct?
Yes, Your Honor.
All right, the court, having heard Dr. Golden's testimony, and by the way, in watching Dr. Golden and listening to his testimony, he does refer to these photographs and looks at them and refers to them in providing descriptions of these wounds. He also looks at his charts and diagrams that were prepared by him and have also been marked as exhibits here. The exhibits presented by the defense, but Dr. Golden has been referring to these photographs not just when requested by the prosecution, but of his own volition, looking at photographs when responding to questions asked of by the prosecution, asking him to describe certain wounds. I can't say he's done that with each and every photograph, but for most of these wound descriptions, he has referred to them. And also going back to one of the other photographs here that was subject of earlier discussions. Exhibit 79, which the court had indicated concerns about its relevance. That was a photograph that has not been shown to Dr. Golden. It has a probe in it, and there was some question in regards to its relevance. And when that wound was described, there was no photograph shown to Dr. Golden depicting the wound. Is there anything that people wish to say about that?
No, Your Honor, only that we would offer it at this time. However, I don't have another photograph aside from the one. I don't believe there is another photograph of that particular wound that depicts it in that way. Yes. So,
All right, that's the wound of Jose Menendez's left elbow.
correct. And I don't know that, I think in his interview with Mr. Burton, Dr. Golden wasn't able to describe why the probe was there, and I think that was his objection. So I would submit it to the court as to whether or not we can show it to the jury.
And you say there was no other photograph depicting that wound?
I don't believe there is, Your Honor. I will quickly look again. Not that I have one up Yeah, Your Honor, I don't have another photograph of that man.
All right, regardless of whether you do or not, the photograph itself is not unduly gruesome, and neither is the photograph that has been marked Exhibit 91, and neither is any of the other photographs that have been or will be shown to the coroner and were the subject of these discussions this morning. And the court has already determined that none of them are unduly gruesome, that the probative value of them exceeds and outweighs substantially any prejudicial effect. And I make that same finding in regards to Exhibit 91, which is a photograph descriptive of and displaying the one of the wounds suffered by Mary Louise Menendez, and also Exhibit 79, likewise, in a non-inflammatory fashion, exhibits and displays the wound sustained by Jose Menendez to his elbow. And as to those exhibits, the court will permit the prosecution to use them, finding that they are relevant and pass the analysis under Section 352 of the Evidence Code.
Your Honor, then I gave her back the two photographs the court excluded, 79 and 82. So I need to get 79 and 81 before.
All right. Do we have all the jurors back?
Yes, sir.
Okay, let's get them in, please. Here are these. And we're waiting for the other jury. As soon as they arrive, we'll proceed. And all of the jurors are back. Both juries are in their respective positions in the courtroom, and we're ready to resume with the testimony of the witness. Dr. Golden, would you get back on the witness stand, please? Would you state your name again for the record?
Irwin Golden.
All right, you may resume your direct examination.
Thank you. May I please, Your Honor?
Yes.
Dr. Golden, I want to return now to the autopsy that you performed on Jose Menendez. I'm going to ask you about the wound, which we have termed here as wound number 4. I believe the testimony was that wound number 4 is the wound to the left elbow. Do you recall that testimony from this morning, Dr. Golden?
Yes,
I have here a photograph which is marked as Exhibit 79, and in the photograph there appears to be a left elbow with some various various defects to it. Is this a photograph of wound number 4 to Jose Menendez?
yes.
And in this photograph, there appears to be some sort of metal object which is inserted into one of the holes. Could you tell me what the name of this object is and why it's there?
It's a probe. I guess to show one of the pellet hole defects.
And for the record, I'm going to place a red dot here next to this with number 4 so that it can be lined up with the chart later on. Now, leaving Jose Menendez and returning to Mrs. Menendez, before lunch you testified about a wound to the left side of her head near the ear, and I believe we called that one wound number 4 as well. Is that correct?
Yes.
Your Honor, I have here a photograph. It's been marked as Exhibit 91. I'd like to show it to the witnesses at this time, please. Showing this photograph, does this depict what we have called in your testimony wound number 4 to Mary Louise Menendez?
Yes.
And I believe your testimony before lunch was that there are 2 separate defects. That is, there's one to the shoulder and one to the near her ear. And it's your testimony that these are probably affiliated because of the presence of birdshot in both the shoulder wound and also in the area near the ear. Is that correct?
Yes.
Okay, I'm going to place this on the board and place a red dot with a number 4 next to this wound too as well. Excuse me, not a red dot, a green dot. In addition, I don't think we've marked the diagram 90 with a green dot for that particular wound, and so this time I'd like to, Your Honor, to indicate that area as well. I have a couple questions to ask you about your testimony this morning before we can proceed. Wound number 2 is the wound to the upper part on the right side of her face, and wound number 3 is to the lower portion of the right side of her face. Referring now to wound number 2, approximately how many individual pellet defects did you see?
Approximately 10.
And as wound number 3, which is lower near her collarbone, how many individual pellet defects did you see?
Approximately 10.
And as to wound number 6, which I believe is on the left breast area, approximately how many pellet defects did you see?
$16.
I think then we're proceeding on to wound number 7. Could you describe for the jury briefly wound number 7?
Briefly, that's a distant type of shotgun wound with multiple pellet defects on the left side of the left hip or thigh region. That would be the outside of the left hip or thigh region, with approximately 11 individual shotgun pellet wounds.
Now, when you say, could you just stand up and show us on yourself what part of the body this is on?
I guess you'd call it the left hip region.
Okay. Well, where the bottom of your pocket is on your pants, is that where it's pointed to? All right.
Yes.
And looking at diagram 90 then, where you've just indicated, I'm going to mark a dot for number 7. I'm going to place it here and make sure it's correct. About here, over on the side, is that right?
Yes.
And was the entry then on the side, sort of towards the front? Was that the entry wound on this particular wound number 7?
Well, it's on the, what I would call the lateral. That's on the outside or the side of the left thigh.
Now, in addition to wound number 7, then there's wound number 8. Could you tell us about wound number 8?
8 is on the back of the left leg, entering anatomically what I would call the popliteal fossa, which is the space behind the left knee.
Okay, so that word that term you just used, you're talking about in the crook of the knee right here. Is that correct?
Yes,
Okay, and so wound number 8 is from behind on the left leg in the crook of the knee. Is that correct?
yes,
Okay, so where I put this this green dot right here on diagram 90, is that
yes, that would be what I would call the popliteal fossa behind the left knee. That's correct.
Now, let's talk about, I believe, let's go back to wound number 7. Wound number 7 was individual pellet defects, is that correct?
Yes,
And how many individual pellet defects approximately did you count?
11.
So that would indicate again a shot from a distance, correct?
Yes,
Now, number 8, which is also on the left leg from behind, what kind of wound was that? Was that individual pellets?
yes,
And approximately how many individual pellet defects did you see to the back of the knee?
9.
Then I believe there's one more injury to the left leg, is that correct? Which is called wound number 9.
Yes.
And I believe in your report, you called it something like a gutter or a graze wound. Could you briefly tell us what a gutter or a graze wound is?
Basically, it's a superficial wound that sort of digs out the surface, the skin, and the tissue beneath the skin.
What is
And it's a deep. It would be like a deep graze wound. It goes beneath the skin.
would that be that the load of the shot was passing by and
Yeah.
nicked or
Yes,
impacted
there.
the skin?
Yes, there are no individual. It's one defect, which means that the shot was clustered and caused one defect, as it grazed or the outside of the left lower leg.
Could you tell what direction the shot was traveling when it made wound number 9?
Yes, it appeared to be traveling. Again, I'm going to have to use my terminology. I said front to back, but that would be basically the front of the leg to the back of the leg, which we would say anterior to posterior.
So if I were facing the shot, it would be from the front of me towards the back of me. Is that correct?
Yes, in that direction. That's
All
correct.
right. And could you tell which way was it going? Straight or up or down? Could you tell that?
Well, on the leg, it was going. Again, I'd have to, in my terminology, would be distal to proximal, which means it would be, if the body were standing straight, it would be going upward, towards the head.
So if I were standing up, it would be from the front and going up. Is that correct?
Up, if you're standing up, that's right.
In the photograph, which we've discussed previously, Exhibit 80, which already has a dot on it, there appears to be some wounds to the left leg, and I'm going to ask you about it, and I'm going to have you do it so the jury can see. You just described wound 9, and I'm going to place a green dot on the diagram 90 for wound 9, which I believe is on the calf of the left leg, in the calf area. Is that correct?
Yes.
And in this photograph 80, which we've already spoken about, we've got the arm and wound number 6. And then you can see in this particular photograph, on the calf, there appears to be this wound here, which you've described. And is that wound number 9, Doctor?
Yes.
Okay, Your Honor, for the record, I'm going to place a 9 next to that. Now, in addition to wound number 9, there appears to be 2 other things on this photograph on the left leg that you can see from the photograph. One is it looks like wounds to the top of the left thigh above the knee. You see that right there?
Yes.
Is that affiliated with the wound to the back of the leg, left leg, number 8?
No.
Okay, what is this wound here?
It appears to be number 7, when we call number 7, on the outside of the,
All right, so this is number 7, is that correct?
yes, I believe, yes.
All right, I'm gonna put a 7 next to that wound. All right, and that's the one you described as being near the hip, and you showed us by standing up, is that correct?
Yes.
In addition, where it appears that the knee is, you can see a little outcropping here, which is difficult to see in this photograph. Is that affiliated with the wound then to the back of the knee?
I'm not sure.
All right, well,
The one I call number 8 enters behind the knee.
did number 8 come out anywhere?
Yes, there were 2 defects of exit associated with number 8. They were on the front of the left leg, just above, and I described them just above the one just below the knee, one just above the knee. 2 small wounds which probed and appeared to be exit wounds from shotgun wound number 8.
So then your testimony is that 7, 8, and 9 then are all wounds to the left leg, is that correct?
Yes.
The last wound that we're going to talk about then is wound number 10. Would you please refer to that in your report? We
Yes.
have here a photograph, exhibit 81. Dr. Golden, this photograph 81, does that depict what you're about to talk about wound number 10?
Yes.
And would you describe for us what is depicted in this photograph and what this wound number 10 is?
Excuse me, Your Honor, before that happens, can you approach this?
Yes. All right, we'll resume.
Thank you. Dr. Golden, the last wound area that we're going to talk about, I think, to Mrs. Menendez, is this photograph, which I forgot what number it is. It's 81. This is wound number 10, correct?
Yes.
Now I'm going to place a green 10 tag next to it. What hand was this?
That's the right hand.
So, and were you able to determine where the entry was and the exit wounds on this particular hand?
Well, yeah, yes, the individual pellet defects are seen on the at the base of the right thumb and also on just below the right index finger. In other words, on the I guess you'd say I don't know if that would be the outside or the inside of the hand. I would call it the radial aspect of the hand.
What
But-
does radial mean? In
Where, well, in our case, it'd be where the thumb is.
All right, so in this photograph, which appears to show sort of the top and side of her right hand and thumb, the entry wounds would have been in this area that's depicted in the photograph.
Yes.
And where were the exit wounds?
There was one large exit laceration that was on the palm. There was an exit laceration on the opposite side of the hand where the fifth finger is. You can't see it. You can't see it in that.
So was the exit laceration on the inside of the hand?
Yes.
Okay, where the palm is,
Yeah.
that correct?
Mhm.
All right, now, is this a defensive wound? Or can you say that?
No, unless it can be shown how the hand would be placed in the proper position.
All right, let me ask you this. How many individual pellet defects did you see in terms of entry wounds to the hand?
To the hand,
Yes.
I numbered 6 individual pellet wounds, and the thumb was fractured, so it was in our terminology, the skin was torn off. It was a vulse, but I counted 6 individual defects. So that would make it a distant type of shot to the hand.
Were there any pellets recovered from the hand?
No.
Did the pellet, would this be what you call a through and through wound?
Yes.
Your Honor, for the record, I'm going to place a 10 here on Exhibit 90 on the back view of the person on the right hand. For the record, and may I have a moment to count up, make sure I have them all covered?
Yes.
Now, the wound number 10 to the right hand, that wouldn't have been fatal, would it?
No.
And how about the wounds that we've discussed since lunch, wounds number 7, 8, and 9? The wounds to the left leg, would those have been fatal?
Each individually?
Yes.
No.
Together, just the three together, would those have been fatal?
Maybe not immediately fatal, but it'd have to be treated. There'd be a lot of bleeding.
Would they be incapacitating to the victim?
Yes, I believe I described several fractures of the leg, including the femur or thigh bone on one of these wounds. Also, the fracture of the thumb on the right hand.
Now, as to Mary Louise Menendez, did you determine what the cause of death was?
Yes.
And what was the cause of death?
Multiple shotgun wounds.
And what was the mode of death?
Homicide.
As to Mrs. Menendez, did you have any toxicology tests done to determine the presence or absence of alcohol or other narcotics or drugs?
Yes.
And were any of those things detected?
No.
One other thing. You described the wounds to both Mr. and Mrs. Menendez, and would you be able to tell, let's start with Mr. Menendez, were all of the wounds inflicted before death or at death?
That's a compound.
Okay, were all the wounds inflicted before death?
They appear to be so, yes.
Now, is there a medical term that you use to describe wounds which are inflicted before death?
Yes.
What is it?
Antemortem means before death.
And post-mortem is after death, is that correct?
Yes.
And then there's the term peri-mortem. What does that mean?
That, by definition, would be at or around the time of death.
Now, how is it that you are able to determine that wounds occur before death, that is ante-mortem?
A wound inflicted before death will show bruising, redness caused by bleeding into the tissue.
When you conducted this autopsy, did you look along the paths of the wounds to see if there was bleeding along the paths of the wounds?
Yes.
What does bleeding indicate if you see it along the paths of the wounds?
Well, the bleeding or bruising would be associated with a wound inflicted before death. A wound inflicted after death ordinarily would not be expected to cause bruising or bleeding into the tissues.
Do you consider bruising and bleeding to be the same sort of phenomena in terms of?
Not necessarily. No. A wound can bleed after death, but that means blood is just oozing out through a defect. That can happen. That often happens. I'm talking about a vital reaction indicating that there was life or blood pressure before the wound was inflicted.
Now, as to Mr. Menendez, did you determine that all of the wounds were before death?
Yes, I believe I've stated that.
And as to Mrs. Menendez, did you make that same determination?
Yes, nothing appeared characteristically a post-mortem wound, meaning a wound inflicted after death. They all appear to be associated with bruising or a vital reaction, yes.
I have no further questions of this witness at this time.
And who is going to cross-examine first?
I am, Your Honor.
All right, Mr. Burt. Yes, you may.
Good afternoon, Dr. Golden.
Good afternoon.
Sir, I think you said that both these autopsies were performed on the 23rd of August. Is that right?
Yes.
And where were the bodies between the time the police discovered them, which the jury has heard is on August 20th, and the 23rd when you performed your autopsies?
They should have been in the coroner's office.
And is it true from your answer that the first time you saw the bodies was when you actually performed the autopsies themselves?
Yes.
Do you have someone in your office who actually responds to the scene where bodies are found to make certain observations as to the condition of the bodies at the place where they're located?
Yes.
And in fact, was an investigator from your office sent out to the scene where these bodies were found?
Yes.
Did that person make a report which you have seen in the course of performing your analysis of these bodies?
Yes.
Could you tell us who the person was who was sent to the scene where these bodies were found?
Yes. It was Mr. George White.
And what time, according to the report which you read, did Mr. White arrive at the scene where these bodies were found?
Well, I'm reading the report. The call was received at the coroner's office on 8/21/89, 03:57 hours. Mr. White does not indicate when he arrived. At least he doesn't indicate in this report right now that I'm looking at. I can tell you about his measurements.
Well, let me ask you another question to see if we can pinpoint it a little bit. One of the things you said this morning was that one of the reasons you could not determine the time of death was because someone in your office did not take certain measurements in a timely manner. Is that a fair summary of what you were trying to say this morning?
Yes.
And is one of the things that Mr. White was supposed to have done when he arrived at the scene of these bodies was to take the temperature of the air, the ambient condition of the air at that point?
Yes.
And is it also standard procedure for him to take the temperature of the body?
Yes.
And how is that normally done?
It's done through a liver thermometer.
And that's normally done right there at the scene where the body is discovered before the body's transported to your office, right?
Yes.
Now, did he do that in this case?
Yes.
And can you tell me what measurements he made and when he made them?
Yes. Air temperature was 68 degrees Fahrenheit, and that was 05:35. That's 5:35 in the morning, 8/21/89. Then the liver temperature was taken 05:44 hours, 8/21/89.
Now, we're talking about Jose Menendez, correct?
Yes.
And did he also take separate measurements for Mary Louise Menendez?
Yes.
And what were the measurements?
The air temperature was 68 degrees, time 0600 hours, 8/21/89. The liver temperature 91 degrees, 0608 hours, 8/21/89.
All right, so tell us how you as a coroner can use those measurements to determine time of death.
Again, it wouldn't be time, it would be a range approximation. As a coroner, I would assume the body temperature started at, let's say, 98.6 or 99 degrees, and then the fall of the...
That's prior to death, right?
Prior to death, yeah.
Okay.
And that again, is not certain either. It could be 100. That's unknown to me.
We're talking averages.
Yes.
Okay.
Normal average temperature could be 98 also. And then I would calculate on each individual the fall or drop in body temperature. So in the case of Mr. Menendez, it would be from, let's say, 99 to 90 degrees, a fall of 9 degrees. And then I would have to assume the rate of drop, which again is not uniform. That's why these measurements aren't precise. So,
And what would you assume the rate of drop to be?
well, it could be 1.5 degrees per hour.
That again is just an average.
That's right. It is an average. That's correct.
And so how do you use that average and extrapolate back to come up with an estimation of time of death?
Well, I would divide the number of degrees of drop, which in this case was 9 degrees by 1.5. You can do it divide by 1 and get 9, divide by 2, be about 4.5. So if you would calculate that, that would be 6 hours, which would be impossible because the body was found at 2350 on 820, and that's more than 6 hours according to the calculation. If you went back from 5:35 and go back 6 hours, it could possibly be around that time.
And how is it that the delay in taking those measurements caused your estimates to be even more inaccurate?
Well, the closer you are to the time of death, the more accurate the measurements would be.
And I think you mentioned other ways in which you can determine time of death, and one of the things you mentioned was rigor, rigor mortis, correct?
Yes.
Tell the juries how you use that phenomenon to measure time of death.
Again, it's an estimate, and it is not precise. Rigor mortis, the stiffening of the muscles after death, begins several hours after death, beginning in the muscles of the jaw and then proceeding down to the limbs, lower and lower extremities. Usually, it's said to be complete. In other words, fully established somewhere between 10 and 12 hours after death.
10 or 12 hours after death, it's well established.
That's the usual figure, but it can be shorter after vigorous activity. It can be longer. It depends on a variety of factors.
And in fact, in this case, your deputy noticed when he was there and noted in his report that both bodies had well-established rigor mortis, correct?
Yes.
So if you extrapolate back 10 hours from the time that he made that observation, that couldn't possibly be right, could it?
Doesn't appear so. It does not follow the liver temperature measurements.
Is it fair to say that within your field of forensic pathology that estimating time of death is one of the most uncertain things that you do?
It is very uncertain, yes.
And in this particular case, you couldn't venture any opinion to these juries with any reasonable degree of medical certainty as to what the time of death was. Isn't that true?
Yeah, yes, just from the measurements on the body, no, I could not.
And you have no other way of doing it, correct?
Only thing I can say is sometime before the body was found, 2350 hours on 8/20/89. That I guess I can be reasonably sure.
All right. That kind of goes outside the area of your expertise and depends more on logic than anything else, right?
Yes.
We don't need a forensic pathologist to make those deductions, do we?
Probably not.
All right. Now, could I approach a witness, Your Honor?
Yes.
The autopsies which you performed, I think you performed the autopsy on Jose Menendez first.
Yes.
And tell the juries how you go about performing the autopsy. Everybody's got an idea from television how that's done, but why don't you tell us just in general how you go about performing the autopsy? Is there a microphone that you're dictating into?
No, we don't. At the LA coroner's office, we don't use a microphone. It's a very busy place. We make the diagrams as we are performing the autopsy, diagrams and notes, and then dictate the report the same day shortly thereafter.
So in other words, right at the autopsy table, you have blank diagrams, and as you're performing the autopsy, you're kind of scribbling down in doctor's handwriting what you're observing. Is that fair to say?
I guess if you want to characterize it as scribbling,
Well, showing you what's been marked as exhibits. First of all, exhibit 87. Is that the packet of diagrams which was produced as a result of your autopsy of Jose Menendez?
yes,
And basically, does this packet of diagrams show each wound which you've described for the jury, along with what I would characterize as scribbling, but I'm sure you could read that for us, right?
I could read most of it, yes.
Okay, most of it. And how about 88? Is that the packet of documents that represent the diagrams you made with reference to the Mary Louise Menendez autopsy?
Yes,
Okay. And after you take down those notes, you then, at some later point, go back and dictate a formal report, which is a more elaborate recordation of what you observed and the conclusions that you reach. Is that correct?
yes,
And the last item in the report is usually your opinion as to the cause of death, correct?
yes.
And the manner of death.
Well, the opinion gives a summary of the basic findings. The death certificate gives the cause and manner. It's required by state law to issue the death certificate and to give a medical opinion, which is not legally binding, of the mode of death.
The means and the mode are the same thing. It's just a different way of saying the same thing.
The mode or manner, it would be the same thing. That's right.
And in this case, the cause of both deaths of both of these decedents was multiple gunshot wounds, correct?
Shotgun, yes,
And the means or the mode of death, you said, was homicide, correct?
yes,
Now, does that mean that you're simply making a determination as to mode that it's death at the hands of another?
yes,
It's not a legal opinion on your part that it's murder or some lesser degree of homicide. You're simply saying by that opinion, as you're legally required to do, that it appears to you that it's death at the hands of another.
that's absolutely correct.
In other words, that it's not suicidal
Yes,
and it's not accidental.
yes,
Whether it's a justifiable homicide or not is for the jury. It's not for the coroner's office in the course of your duties, correct?
yes,
And that's what you meant when you referred to homicide.
yes.
All right. Now, in reference to the Jose Menendez autopsy, I'd like to direct your attention to a few of the specific wounds that you talked about. And the first one we're going to talk about is what you've designated as wound number 1. Actually, in your report, the first wound you described is the abrasion on the right thigh area, correct?
Yes,
And just looking at the diagram that's been placed on the board, that would be a red mark that is on the right thigh that doesn't have a number on it.
yes,
We described that as a recent abrasion, correct?
yes,
And you didn't mean to imply by describing it as a recent abrasion that that abrasion was necessarily associated with the same time that the shotgun wounds were inflicted, correct?
not necessarily. It's just consistent with, as I think I described earlier, with the marks you very often see with shotgun wounds. Well, no, not necessarily.
And it could be equally consistent with an abrasion which the decedent may have suffered sometime earlier, which may have been inflicted at a time when the shotgun wounds were not inflicted, right?
It's possible, yes.
He could have been out playing tennis and scraped himself or whatever. It wasn't necessarily in your mind associated with the same time that the shotgun wounds were inflicted.
Again, I'll say it's consistent with the marks you frequently see on distant type of shotgun wounds, the wad marks, but there's no way I can say 100% that it's a wad mark. from the shotgun wadding, but the distant shotgun wounds, as most of these are in this case, are associated with these round or what I call annular abrasions.
Okay, let's take a short break and we'll resume at 1:45. Don't discuss the case with anyone, ladies and gentlemen. Don't form any final opinions about it. And we'll resume at 2:45. While the defendants are in court with their attorneys, people are represented, and we'll have the jury come out. Any matters that council wish to discuss before we're ready to proceed?
Just one issue, Your Honor. There was a blow-up of a photograph. It had previously been marked by the people as Exhibit 7. We had objected to that photograph going into evidence. The court overruled the objection, and the people have had marked as, I believe, 7A, 7B, smaller enlargements of that same photograph, so that we had two for each jury. I just wanted the record to reflect that those photographs were offered by the people, not by the defense.
What is it the people want to do? Substitute the smaller photographs for the larger one, or?
No, Your Honor, what happened is the court wanted 2 copies. I couldn't get the same size of 7. All I could get were 8 by 10s. Mr. Burt wants to use number 7 in the jury, so I gave him the 2 8 by 10s, which had not been marked prior to today. So 7 is the photograph we discussed with one of the first witnesses, and the 2 smaller ones are 2 copies for each jury.
All right. You parties may do what they want with those photographs. You want to use the smaller ones or the one larger one as you see fit. All right, we ready to proceed otherwise?
Yes.
Okay, let's get the jurors in. And all the jurors are back for both defendants, and we're ready to resume. Dr. Golden, would you get on the witness stand again, please? All right, Mr. Burt.
Dr. Golden, before the break, we were talking about whether the thigh wound to Jose Menendez on his right thigh may have been pre-existing, that is, existing before the time when the shotgun wounds were inflicted. And I asked you a question about that, and I think you indicated that the wounds were consistent with perhaps the wadding of a shotgun charge striking the thigh area. Is that correct?
Yes.
And isn't it true that it's also consistent with the abrasion being pre-existing?
That's possible too.
All right. Now, that was the first wound you described in your autopsy protocol, and the second wound I think you described as the contact wound to the head. Is that right?
Yes, that was the first shot. That was the first shotgun wound. Yes.
And on the diagram, which is behind you there, the dot, which is depicted as number 1, shows that, at least according to the dot, the wound was inflicted on the right side of the skull. Is that accurate according to your autopsy?
No, she put it next to the head, but it's actually on the back of the head.
And I wonder if you could yourself put it where it would accurately reflect where the wound was located on the back.
Just on the back of the head, below the crown.
So here, more to the left.
May I see where your hand is? Right in the middle.
Do it, then there won't be any dispute as to where. Okay. For the record, we'll move the dot on the diagram for the Lyle Menendez jury in the center. And could you tell from your examination the direction of that shot?
The direction is from the back of the head forward. In other words, back to front.
Back to front, and I think you said that there was an exit wound, which was actually on the right side of the face. Is that right?
Yes.
And there were 2 exit wounds, were there not?
Yes.
There was an exit wound which came through the ear,
Yes.
and the other one was on the right temple, correct?
Yes.
And was the trajectory of this wound from left to right, or was it straight ahead?
It'd be hard to tell, but going out on the right side just indicates ricochet from the main mass of pellets. That does not indicate trajectory. There's going to be ricochet inside the skull, so that doesn't indicate the trajectory.
Is there anything that you can tell from your examination where the gun was positioned in relation to the wound, in the sense of whether it was straight ahead or slanted to the left or slanted to the right?
Not from my examination, no.
And was there anything in your examination from which you could tell where the shooter was in relation to the head wound? In other words, was the shooter or shooters off to the left, directly behind the person, or to the right?
No, I can't tell that. I can only tell you the approximate location of the muzzle of the gun, and that was a contact. But I can't say anything about the shooter.
And would one of the reasons why you can't say anything about the shooter be because perhaps the parties were moving at the time that that particular wound was inflicted?
That, and I don't know which way the head was turned, and I don't know how the weapon was held, so there are a lot of variables. The position of the shooter is not known to me. There are too many variables. Each body can move in different ways, and I don't even know how the weapon was held.
And I have two photographs that I'll mark defendants next in order, one for each jury. Another photograph which I'll have marked in duplicate is 93.
Can you describe these photographs? 92.
Yes, 92 is a crime scene photograph depicting the back of the couch area where Jose Menendez is seated on the couch. And 93 is a photograph of the wound to Jose Menendez going through the left thigh. And the photograph depicts him seated on the couch. Could I approach a witness again, Your Honor?
Yes.
Thank you. Okay, let me show you that in close-up, and then I'll put it up on the board.
Yes.
Right. Do you recognize that photograph as depicting Jose Menendez seated on the couch at the location where the body was recovered?
Not by direct recall, but I was not present at the scene, if that's what you meant.
Can you take my word for it for now that that's what it represents?
Yes.
Later established. I think there'd be a stipulation that's what it represents. Is that correct?
Is that what you want me to-
Yes.
That is a photograph from the crime scene. That's so stipulated.
Thank you. And doctor, directing your attention to that photograph, you see behind the body as it's seated there on the couch is an area, a narrow area, and next to the area is what looks to be two doors. Do you see that?
Yes.
And nothing in your examination can tell us whether the shooter was standing in the area directly behind where the body is depicted in that photograph, correct?
From my examination?
Yes.
No.
And as I think you said, one of the reasons why you can't determine that is because Jose Menendez may have had his head turned at the time that wound was inflicted, correct?
Yes.
And depending upon where his head was, that would be one factor in determining where he was in relation to the shooter, correct?
Yes,
So you just don't know from your examination where the two parties were standing, or three parties were standing, or more parties were standing at the time that wound was inflicted. Is that correct?
yes,
Now, I think you also testified that that wound, that is the wound to the head, was the only contact wound of the 5 shotgun wounds that you described in relation to Jose Menendez.
yes,
And I think you also testified that with respect to Mary Louise Menendez, there was also only one contact wound, and that contact wound was to the left cheek area. Is that correct?
yes,
And all the other wounds you described were non-contact wounds. Is that right?
yes,
And I think you classified in terms of the way you describe wounds as contact wounds, close wounds, and distant wounds, correct?
yes,
And all the other wounds, except for the 2 that we just talked about, were distant wounds, correct?
yes,
And I think you indicated that you couldn't pinpoint for the juries exactly what that meant in terms of how far the muzzle of the gun was from the target at the time the shots were inflicted, correct?
that's absolutely right.
You can give us a range or an average or an estimate, but it's only that. It's just an average.
That's correct.
And I think you said that a distant shot starts to be defined as 5 or 6 feet or more away from the target.
That's correct. Ordinarily, and I indicated also, shorter barrel, sawed-off shotgun, a distant shot would be closer than that.
You know,
Full choke, it could be 18 feet, but
closer in the sense that a sawed-off shotgun will cause a distant shot at a closer
yeah,
range.
that's correct.
Correct.
The spread starts sooner, maybe 3 feet.
Right. The firearms examiner in this case testified, I believe, that the barrel of the gun that he examined was 18 and a half inches in length. So that's not a sawed-off shotgun, right?
That's getting close. Under 20, under 20 maybe. Again, I'm not a firearms examiner, so I wouldn't know exactly.
And when you say you wouldn't know exactly, what you mean by that is in order to determine exactly what the range would be for a distant shot, you'd have to fire the same weapon using the same ammunition.
Absolutely.
Now, as you step back, that is, as a shooter steps back from his target, beyond that 5 or 6 feet range, will the distant shot look exactly the same? In other words, will you see the same sort of characteristics for the wound?
No, the pattern starts spreading out. If you think of it as a circle of spread, the diameter of the circle will start increasing.
The further you go back, the more
further-
spread you're going to get.
That's correct.
And what in your examination tips you off that it's a distant shot is this satellite effect that you testified about, correct? That is,
Yes.
the shots appear to be spreading.
In other words, there's not one central or major hole. There's just a series of individual small holes.
And you also look to see if there's any gunpowder or gases sprayed onto the wound.
That's correct.
That will tell you whether it's a close-in
That's it.
shot.
That's at closer range, yes. A shotgun wound at closer range would be expected to leave smoke or powder on the target. That's correct.
And you saw none of that with reference to any of the wounds except for the 2 contact wounds, which we have talked about earlier, correct?
That's correct.
All right. Now, one of the wounds you described was the thigh wound to Jose Menendez, correct?
Yes.
And that's wound number 5.
Yes.
And I think you said as to that particular wound that you recovered no pellets inside the wound, correct?
Yes.
And I think you also testified that the direction of the wound was from the inner part of the thigh to the outer part of the thigh. Is that also correct?
Yes.
And again, may I approach a witness?
You may.
Showing you photograph number 93. Could you just take a look at that photograph? And I think it would again be stipulated this is a photograph taken at the scene when bodies were recovered. Correct, counsel?
Pardon me, I'm sorry.
Stipulate to the photograph that it's an accurate
Yes.
depiction of
The crime scene.
the body at the place where it was located.
Yes.
Yes.
Right.
I would stipulate it was located by the police.
And doctor, if you would, could you step down and just draw for the jury with a pen, which I'll give to you, the direction that that wound to the left thigh would have been going in based on your examination? Yes. Okay, thank you. And since there were no pellets inside the wound, you
Mr. Burt, you would like him to mark the other photograph as well so that we
Yes,
have the same
we'll do
marking?
that. Handing you the other photograph, if you could just also draw that same arrow.
And that exhibit number was what? That was
Counsel,
93?
93, I believe. Okay. Doctor, with reference to this wound, your arrow indicates that the wound comes in on the inside of the thigh and goes out in the direction indicated by the arrow, correct?
Yes.
Now, as the pellets enter that wound, and you don't find any pellets in the wound, what happens to the pellets when it comes out the other side of the wound?
I'm not exactly sure what you mean by what happens to.
Well, what direction, since there are no wounds in the pellet,
Yeah, the leg is
no
actually,
pellets in the wound, what happens to the pellets?
they go out in the direction of the arrow.
And is there also material, blood, and body particles that are blown out in the same direction?
Yes, it's very possible.
And do you see on this side of the couch any indication that there's blood or body particles?
Well, I don't see any, I don't see anything to my unaided eye examination, no.
What does that suggest to you as a forensic pathologist as to whether Jose Menendez was seated at the time that wound was inflicted?
Well, the way that picture shows, the exit wound is in front. Am I incorrect? The exit wound appears to be in front of that couch and not right next to it. I'm not sure whether it's the exit wound is so far in front of the. I don't have a good depth perception. That wound on the left side of the thigh in the picture would be on the right, but on the outer side of his left thigh may be so far in front of the couch that it just missed it.
And where would it go if your perception of that?
It would go towards, on the photo, it would go towards the right, to the floor or something like in that direction.
All right. I have another photograph by Mark.
All right, you don't have to approach the clerk at this point. Just put marks on the back of them with a pen so that we know what they are.
Should be
94. All right, these are photographs of what?
I will stipulate that these are crime scene photographs. I believe.
All right, I just want Mr. Burt to describe it for the record. What is it?
says another angle on the same area depicted in 92.
The sofa area?
Yes.
All right.
Doctor, showing you first so you can take a look at it, 92. Does that help you any on the perspective?
This is 94.
94.
Yes.
And now let me put that up if I could. What does that tell you in respect to where the leg was situated near the couch?
Well, it was exactly there at the time the wound was inflicted. I mean, in that location, there may have, you might expect some blood soiling on the material, if that's exactly where it was at the time.
And
Because it appears to be very close to the wound.
in other words, you would expect, given the direction of that wound, that if he were seated there at the time the wound was inflicted, you would see some blood soiling in the area of the couch to the left of the body.
Very likely, yes, that's correct.
Okay. And I think you also described that you had certain wounds to the back of Jose Menendez's arms, correct?
Yes.
And where were those wounds located?
Well, one was on the left elbow. That was the one we call number 4. And on the back of the right forearm, that was another entrance wound. That was number 3.
And showing you, it's been marked as 7B.
What photograph is that, please?
7B is a photograph that I believe is in evidence.
Oh, okay, sorry.
You see in this photograph, doctor, that Jose Menendez is seated on the couch with both of his arms up against the back of the couch, correct?
Yes.
And is there any way that the shotgun wounds that you saw that were inflicted on the back of his elbow, the left elbow, and the shot to the back of the right arm, could those have been inflicted while he was seated in the position in which he's shown in that photograph?
Not on the back of the left elbow. It would have to go through the, if it was, that's the exact position, it would have to obviously go through the I guess you'd call that the arm. It would have to go through the couch. And on the back of the right forearm, if the back of the right forearm were on the seat of the couch, there's no way it could go through. The arms would have to be removed from the couch in order for those wounds to be inflicted.
In other words, the only way it could happen is if someone shot through the back of the couch into the arm as they rested in the position they're depicted there.
Yes.
The other possibility is that he's up and moving and has his arms in such a position that the shots are inflicted while he's moving and standing up.
That, or if just the arms are elevated while he's sitting, as long as there's no couch in the way, yes.
And the fact that those wounds to the back of the left and the right arm are in the back, that does not in any way suggest to you that the shooter is necessarily standing behind Jose Menendez when those wounds are inflicted, correct?
That's correct. That's why I say posterior and anterior instead of back or front. That's correct.
Because he could be moving his arms in such a way, if he had them up, for instance.
In other words, I can be facing you and I can put the back of my hand or arm facing you.
All right. And with respect to Mary Louise Menendez, you also have wounds to the back of her leg. Is that right?
Yes.
And again, those wounds could not have been inflicted if she was in the position she's depicted in that photograph, correct?
It appears that the back of her body, including her leg, is against the couch. Is that the correct assumption? It's lying against the couch.
So that it appears from the photograph, but you
Well,
tell me.
then there's no way the wounds could go through to the leg and not hit the couch. So it appears to be impossible. And there's no indication from my exam that any of the wounds went through the couch.
So again, there must have been some relative movement by her at some point when those wounds were inflicted, correct?
Yes, or that she was not near, that was not the position, her final position was not where the wounds were inflicted.
Now, I think you described all of the wounds as being anti-mortem, correct?
As best as I can tell with a normal pathological examination, all appear to have bruising or vital reaction, yes.
And I wonder if you could explain for us a little bit more. You were discussing earlier that bodies after they're dead can bleed, but that's not what you're talking about, is it?
No, that's not what I'm talking about.
Tell the juries the difference between what is seen in photographs in this case where blood is coming out of wounds, and the kind of hemorrhaging that you're talking about, which allows you to determine that wounds are either inflicted before or after death.
Well, it's basically what I'm talking about is the bruising caused by a wound on a living body. If a living person, you or I or anyone, causes an injury, whether it's a cut or a bruise or a scrape, the tissue turns red because of the bleeding into the injured area, whether it's capillary or a small blood vessel. And that's the vital reaction. On a dead body, that will not occur. If you scratch a dead body, it won't turn red. It'll be a yellow color. If you strike a dead body, what would ordinarily cause a bruise or a welt, that bruise or welt will not happen. So we're talking about a vital reaction on a living body.
And this vital reaction you're talking about happened up to the point in time when the heart stops pumping blood.
Yes.
And that's what you mean by anti-mortem.
That's right.
That is that there's some blood pressure at the point in time when the wound is inflicted.
That's correct.
And I think you said that all the wounds in this case, anti-mortem, and in particular the wound to Jose Menendez's head, you described as instantaneously fatal?
Oh, no, I think I modified that and said I couldn't give an exact time. I said it would appear to be a rapidly fatal wound from all the injury. But I went into some description that a forensic pathologist can't give the exact time of death or duration of survival.
Now, how did you describe the wound in your autopsy report? I don't mean the entire wound, but as to whether it was rapidly fatal or...
I said in the report, I said immediately fatal.
You said immediately fatal.
Yes.
And by fatal, you mean that the heart would stop pumping blood
Or
very rapidly.
Yes.
Now, was there anything in your examination which allows you to tell the juries anything about the sequence of the shots? That is, which wound was inflicted first, or who got shot first, as between Mary Louise Menendez and Jose Menendez?
No.
One of the things your examination did indicate was that this head wound was, as you described it, immediately fatal, correct?
Well, upon further reflection, I think I testified earlier that I would say rapidly fatal.
All right. And if it was immediately fatal, and that head wound was the first wound inflicted, would that mean, according to what you've told the jury so far, that the rest of the wounds inflicted on Jose Menendez would have been post-mortem wounds?
Post or immediately post-mortem, if there was a rapid sequence.
So in other words, if the sequence of the shots was the head wound first, and the person died immediately as a result of that head wound,
Yes,
and then started shooting the body in other areas, then those wounds you would see at the autopsy as being post-mortem wounds, right?
if the heart stopped immediately, if there was no blood pressure, very likely the other wounds in the sequence would look somewhat different. There wouldn't be as much hemorrhage, or as we would say, bruising or vital reaction in those wounds. That's correct.
And you're saying that those wounds, in this case, based on your examination, those wounds were anti-mortem wounds. That is, the wounds other than the head wound.
Yes, yes. Everyone had the vital reaction, the bleeding along the wound path, the bruising. That's correct.
Which means that one consistent interpretation based on your examination is that all of the wounds except the head wounds were inflicted, and then the head wound was inflicted last. Certainly consistent.
That is very consistent interpretation. Yes.
And if it had been the other way around, that is, if the head wound had been inflicted first and he had died immediately, then that would not be consistent with your examination, because those other wounds we know were not post-mortem, correct?
That's correct.
And when you say you're modifying somewhat your interpretation of whether the head wound was immediate, I think you explained that that is based on reports in the literature that you have read, indicating that sometimes people with serious wounds survive for some length of time, right?
That's correct.
But in this particular case, you have no evidence to suggest to you that that happened, correct?
That's correct.
And it could very well be that that wound to the head was immediately fatal, in the sense that most people think of immediate, that is instantaneous.
Yes.
Doctor, if we could just for a minute turn to the Mary Louise autopsy. And I think you said that your examination revealed the 10 separate locations of injury. Is that correct?
Yes.
And are we clear at this point that the 10 separate locations of injury in no way means that that's the number of shots that were fired?
That's correct. In fact, I think that some on the face may be either one shot or possibly one on the face, particularly the right side, may have passed through the hand. So that's correct. I can't give an unequivocal number based on that. I give the maximum number that I've identified, if everyone is an individual shot.
And is one of the reasons why some of those shots could be coming from, some of those wounds could be coming from the same shot because of the nature of a shotgun. That is, it's a scatter gun.
Yes, very especially in the distant shots where there's a scattering of pellets. That's correct. More than one part of the body may be struck. Very often that happens.
And so the number of wounds in this case, with respect to Mary Menendez, does not tell a jury how many shots were fired necessarily, does it?
Not necessarily, no.
And the same thing with respect to Jose Menendez, correct?
That's correct. In fact, I think the one on on Jose Menendez, the one on the chest, I had an individual wound, most likely is related to the group on the right arm, because it would be unlikely just to have a once isolated, let's say, flyer on the right side of the chest, and with the arm most likely being against the side is most likely all one shotgun wound.
And it's also true, is it not, that some of the wounds could have inflicted injuries on both Jose and Mary Louise. That is, they could have passed through one person and into the other.
That is possible under the appropriate positions and circumstances of the two victims. Yes.
And how does that happen? If you could explain that just a little bit.
Well, in the same way that a shotgun wound can pass through two parts of the same body, a cluster of shotgun pellets can pass to parts of different bodies if they're close enough. In other words, a volley of shot can go through, let's say, a thin portion of a person's body, let's say a limb or a hand, and then continue on and strike another person.
And it's also true, is it not, that with shotguns, and especially with distant shots, that as the shotgun pellets scatter out, that some of the pellets may hit one target and some from the same shot may hit another.
That is true under the appropriate circumstance. That's correct.
And in this case, in fact, your examination revealed that most of the wounds, with the exception of two, which I'll get to in a moment, were buckshot wounds, correct?
Two definitely were the birdshot, the tiny ones. The others, I didn't characterize what size shot they were, not being a firearms examiner. I just call them shotgun pellets. I'm not qualified to tell you what size shot they are. That's not my field.
But basically, your examination
Difference.
revealed two types of ammunition, correct?
That's correct.
Birdshot and something larger, which through other evidence may be established to be buckshot, right?
Yes.
And is it also true that as to some of the wounds, especially the ones that you characterize as distant wounds, that the number of pellets you recovered was less than the number which would normally be in a loaded buckshot?
Objection vague.
Sustained.
With respect to Jose Menendez, the number 4 wound, which you've described in your autopsy as a wound to the left elbow.
Yes.
You discovered 9 wound defects with relation to that wound, correct?
Yes,
And yet you only recovered 5 pellets.
that's correct.
And it's possible that 4 of those pellets passed through that left arm, continued on into her, correct?
It's possible.
And you also have wounds with respect to Mary Louise Menendez, where you have the number of pellet defects does not match up with the number of pellets you recovered, correct?
Yes, in many of these, there were so many. I took fewer pellets were recovered than actual individual wounds on the skin. That's correct. So some were left, some were either left in the body or some may have passed through.
Passed through to the other person.
Possibly to the other person, yes.
And again, we don't know the sequence as to who was shot first. It could have passed from Jose Menendez into Mary, or it could have passed from Mary into Jose Menendez, correct?
That's right. The sequence of shots fired is not known to me.
Now, what is known to you is that 2 types of ammunition were present. Does that mean that 2 guns were necessarily used?
No, it just means 2 different types of cartridges. I have no knowledge about how many weapons were used. That just means 2 different cartridge loadings.
In other words, you can take a load of birdshot and chamber it into a shotgun and also chamber a load of buckshot right behind that and shoot it from the same gun, and you're going to have 2 different types of ammunition in the wound, correct?
That's correct.
Could I have 1 minute, Your Honor?
Yes.
Throughout your testimony, you referred to incapacitation, and you referred to incapacitation, for instance, with reference to the thumb wound to Mary Louise Menendez. What does that term mean in reference to a thumb wound? Incapacitation.
Inability to operate or move the thumb or use the thumb.
And when you were using that term earlier, was it in reference to the wound you were describing? That is, if it's a broken arm, then the person is incapacitated in the sense that they cannot use the arm.
Yes.
Doesn't mean that they're down and out or unconscious or anything like that, does it?
No, I make no implication about, as you said, down and out or unconscious, no.
Except with reference to the head wound.
Yes,
That certainly is a wound that would have rendered anyone unconscious, correct?
correct.
And I think with reference to Mary Menendez, you described the wounds, all those wounds, as antemortem also, correct?
Yes,
And does that suggest to you that the wounds in reference to her must have been inflicted in very rapid succession?
yes.
Could you explain to the jury why you reached that conclusion?
Well, the exact time is not known to me, but the longer the duration, in shotgun wounds, especially if they're severe or rapidly fatal wounds, if you wait long enough, then some of the wounds will become post-mortem. So in a sequence such as this, with multiple shotgun wounds, the assumption is that it's a fairly rapid sequence until the actual fatal wound is inflicted.
And would your opinion be the same with reference to Jose Menendez? That is, your examination suggested a rapid sequence in terms of the shots being fired in quick succession.
All the autopsy evidence suggests that, and that they were all ante-mortem.
Thank you. That's all I have, Doctor.
You never went to the crime scene in this case, is that correct?
Yes,
So all you can do is look at photographs that we have for you, correct?
correct.
I'm showing you a photograph which has been marked as Exhibit 95, which appears to depict which side of Mrs. Menendez's body.
The left side.
And now I believe in your testimony you indicated that many of the wounds to Mrs. Menendez, especially to her legs, it appears, were in fact on the left side of the body. Is that correct?
At least two were on the left leg and one on the behind the left knee. That's correct.
Now, in this particular photograph, 95, would you say it's clear that the wound to the back of her knee, which we call wound number 8, could not have been inflicted in this particular position? Can you say that?
If that's the position the leg's in, I don't see how, because that area is hidden or concealed by the bending of the knee.
Now, as to you described injury number 7, I believe, in your testimony. Do you see anything in this photograph 95 that corresponds to injury number 7?
Well, I see a heavy blood stain on the left hip region, extending up to the waist region.
Do you also see the area which you call the graze wound, which is wound number 9, in this photograph?
I believe I do, yes. The heavy blood stain and some dark material on the outer side of the left calf, yes.
In addition, I believe you testified earlier that there were 2 wounds to the left side near her face. One is we call wound number 1, which was the contact wound, and one is the wound area number 4, which is the shoulder and the ear area. Is that correct?
Yes.
And in this photograph, you can't see her head exactly, but it appears that her head is rested on the right side. That would be consistent with what you see in the photograph, correct?
Correct.
Dr. Golden, do you know how long it takes for a human heart to stop pumping blood once there has been inflicted an immediately fatal wound?
Well, if it's immediately fatal, it would be immediate stoppage
Okay,
of
now,
vital function. In other words, respiration and heartbeat.
Do you know in this case how long the heart continued to pump after the wounds were inflicted?
In each individual or just one of them?
Just in any of the wounds in either of the decedents, which you have classified as immediately fatal, do you have any knowledge as to how long the heart would have pumped after those wounds?
No, except the head, the shotgun wound of the head of Jose Menendez may have been. Again, I don't know for sure. The others on Mary Menendez, no, I do not know how long it would take for the heart to stop beating. That's correct.
By the way, do you know how long it takes to empty a shotgun, a 6-shot shotgun? Do you have any personal knowledge of that?
Objection, Your Honor. Hastings facts not known.
Sustained.
Dr. Golden, you've indicated in some of your testimony that shot could pass through one body and then go into another body. Is that correct?
Yes.
Would the passage from one body into another distort the pattern when it gets to the second body?
Objection, Your Honor, because the answer is succeed.
Do you know?
Objection overruled. Can you answer that question? If you have the experience and background to do that?
If by distort is meant change, then yes.
All right, that's what I meant. Would it change the pattern?
Yes, it can. It can cause a ricocheting effect, striking one target, which I would call the intermediate target or the primary target instead of a second. It can cause ricocheting, and then a close clustering can then become a widely dispersed pattern. Yes, that happens.
And lastly, you were asked about incapacitation. And for instance, we talked about the wound number 10 to Mrs. Menendez's hand. Would that be less incapacitating than, say, a wound that goes through the leg? In other words, let me back up. My question is, are some wounds more incapacitating than others?
Yes.
And is incapacitation a term which describes a range of events or a range of possibilities?
Yes.
Okay, thank you. I have nothing further.
Any recross?
Couple of questions. Doctor, is that a photograph that was just put on the board depict what you described as wound number 7 for Mary Menendez?
Yes, I believe so. Yes.
And that was the wound which I think you described as multiple pellet defects,
Yes.
indicating that that's a distant shot, correct?
Yes.
And what is the trajectory or direction of that shot?
Okay, we have to put that in the anatomical position, and I believe that trajectory would be, I'd like to check my report here. That trajectory, as best that I could determine, was from the outside in, and it was slightly front to back and proximal to distal. Proximal to distal meaning going from the toe toward the head.
I wonder on the diagram that's depicted there, if you could draw in some arrows as to the direction of that particular.
Yes.
One. And if you could, just for clarification, draw in the direction of the other moves as well. The trajectory of the other moves.
All of them?
Would you be able to do that? If you could.
I don't think I can on the ones going front to back because.
How about on 7? Do that on 7.
Yes. Seven is hard for me to do because it's going from the outside of the thigh and there's an exit on the back, so it's going inward towards the middle and out the back. So it's from front to back, basically, and maybe a little bit upward. And from outward to inward, it's almost easier to do on the human body. It's basically going inward and sort of out through the back of the thigh. This is left, so that's the back, and there's a big exit hole on the back. So it's going from front to back and inward towards the middle.
When you say front to back, are you meaning perpendicular to where the green dot is?
Well, it's not. It's going inward towards the hip bone and then coming out in the back. So basically, it's going from the side inward a little bit.
So
Front to back means, well, this would be actually front, but it's on the side and it's going out the back of the thigh.
what I would like to know is whether you can show us in terms of the angle at which the shot is coming in.
Oh, I don't believe with a distant wound such as this, that is it's a 3-inch pattern of spread, so that means it's at a again, I don't know, there's no exact way of knowing it, but at a 3 inches, that's going to be maybe several yards away, so that's going to be hard to get an angle.
My question though is the shot coming directly into the thigh as opposed to coming in at some angle?
It's coming in at an angle and it strikes the bone, the femur, and then probably ricochet off the femur out the back.
And what is the angle? Can you draw in the angle at which the shot is coming?
I don't believe so. I think what's happened here is the pellets have struck and fractured the femur, and then a lot of them have ricocheted off the bone and have gone out the back.
And could it be coming in directly perpendicular?
Yes.
In other words, if she's standing up, could that wound 7 be caused by someone standing at a distance and shooting directly into that wound, to that area?
Yes, that's possible. Yes.
And if that is, in other words, that's consistent with your examination.
Yes.
And if that were the way in which that wound was inflicted, would you say, given the position she's in, that the only way that could have come in perpendicular is if someone was on the ceiling shooting straight down? If she's lying down when that wound is inflicted.
Again, I can't tell you exactly where the person was, but the gun would have to be held at a distance away and shot downward if that's her final position.
In other words, if the wound was inflicted while she was lying down, as she's depicted in that photograph, and if the wound is coming in perpendicular, which you say is consistent with your examination, the shooter would have to be up on the ceiling shooting straight down, wouldn't he, or she?
Yes, or several feet, yes.
And the other possibility is she's standing up, is moving or in a stationary position, and the wound comes in directly into the thigh and passes through, and the exit wound is caused in the way your examination indicates.
Yes, that's another consistent interpretation, yes.
And wound number 8, which is the shot to the back of her left ankle, that could not possibly...
The popliteal fossa, behind the knee.
Yes. That wound could not possibly have been inflicted while she was in the position she's depicted in that photograph.
Yes,
right?
that's correct.
That's all I have. Thank you.
All right, anything else?
No?
Okay, thank you. You may step down. You're excused.
Thank you.
All right, the next witness will be tomorrow morning, and council will be discussing some matters with me this afternoon and also tomorrow at 9. So we'll get started at 10 o'clock tomorrow morning with, people are going to be proceeding with the jury of only Eric Menendez in the morning. Is that right?
Yes.
All right, and how long do you think that would take? Okay, so what we'll do is ask that the Eric Menendez jury be here at 10 o'clock tomorrow morning, and that the Lyle Menendez jury be here at 11 o'clock tomorrow morning, at which time we'll resume. The Eric Menendez jury, if you would report to this courtroom and go into the jury room, and as soon as you're ready, we're ready, we'll have you come out and we'll begin. And the Lyle Menendez jury, if you would go next door to the courtroom next door and report in there and wait until we give you the word to come back into this courtroom, and then we'll have you in as well. And just to remind you not to discuss this case with anyone, not to form any final opinions about it, not to look at or be exposed to any news coverage or any other coverage about this case or discussions of it or any mention of it in any source. And we'll see you all back here tomorrow at the indicated times, 10 o'clock for the Eric Menendez jury and 11 o'clock for the Lyle Menendez jury. And as soon as all the jurors leave, we'll continue on with our discussions. The jurors have left. Just to document the record, the people at the sidebar prior to the marking of Exhibit 95 also had another photograph that you presented to the court depicting the body of Mary Louise Menendez, and we'll mark that 96 for the purpose of identification only.
I'll give this to the clerk, Your Honor. May I approach you up to here, Your Honor, and start gathering exhibits, please?
Yes, and at the sidebar, counsel indicated that there was a matter that you want to discuss, or several matters you want to discuss in anticipation of Dr. Oziel's testimony. So
Well-
I would ask that you enumerate what it is that you wish to explore for the hearing tomorrow morning.
Our concern is privilege. And our concern is what matters the people are going to be able to go into based on other rules this court has made that we may consider violative of the psychotherapist patient privilege. And what matters that we go into on cross-examination is this court likely to rule it somehow opens the door and waives the privilege. And specifically, one thing we simply forgot to do when Dr. Oziel was here last was I had indicated to the court that there were two in-camera matters. One of them had to do with attorney-client privilege, and we did have that hearing. But there was another in-camera matter having to do with the disinherit information that I admit and apologize to the court, I simply forgot when Dr. Oziel was last here. And I would like therefore to very briefly have that hearing. Now, one of the basic problems I'm having in trying to prepare cross-examination for Dr. Oziel and understand where it's going is this. The court is allowing the people to bring out the fact that my client was involved as a juvenile in this grand theft and burglary. If I understand the rule, on the theory that it's part of the parent-child relationship, and it was the reason why Eric was seeing Dr. Oziel in therapy. Now, if that's the justification, then my suspicion is that the court has de facto ruled that the fact that Eric was in therapy with Dr. Oziel for a previous year is no longer privileged, although ordinarily that would be a privilege. The fact that you are a patient in therapy is privileged.
Well, as we discussed before, your client told Detective Zoller of that fact. Your client waived that privilege by disclosing it to Detective Zoller, and you felt that there should have been some admonition by Detective Zoller, similar to a Miranda admonition, prior to your client blurting that out, but the law is otherwise. So your client made that disclosure. It's not anything that anyone else has done, but your client did so out of his own mouth.
As I said to the court, I don't really want to argue these things right now, but I do want to know the implication of that. Now, what can the people ask Dr. Oziel about that prior therapy? That's one of the questions I'd like to know. And, I mean, how far can they go? I mean, is the entire privilege waived? Because the Supreme Court certainly never decided that, and the people never raised that issue previously, and so it's never been litigated by a higher court. I have that question. I have another question, which is, if the people are going to establish this prior therapy, are they also permitted to prove that Lyle Menendez was a patient for the prior year, and that Dr. Oziel met with the parents on numerous occasions during that prior year? And if they don't prove that, and we try to prove that, does that waive the privilege for the contents of those sessions, even if we haven't offered context, but just the mere fact that the whole family was seen by Dr. Oziel? And then another issue, Your Honor, is that the parents were not per se patients of Dr. Oziel. He characterizes them as consultants. Therefore, if the parents are not patients, if we were to inquire about things said by the parents or about his opinions or impressions of the parents, have we waived the privilege for the confidential communications by the boys, which are not taking place in the same sessions as the parents? That's another question that I have. Then there's another issue, which is this, and this has to do with the general issue of Dr. Oziel and his note-taking routine or lack thereof. As the court knows, there are two tapes that were the subject matter of the litigation before the Supreme Court, November 28th and December 11th. Tapes of two sessions on those dates, those notes, therefore, of some type. If we wanted to indicate that, for example, my client, Eric Menendez, saw Dr. Oziel after December 11th, and that he made no notes of those sessions, does that, trying to prove that, mean that somehow we are waiving the privilege as to December 11th or November 28th, for which there are memorializations of one sort or another? Does the fact that we concede that Eric is still seeing Dr. Oziel after December 11th waive anything with respect to those last two sessions? In other words, I need to know what it's going to take to swing open this door, a zephyr or a cannon, if you will. I need to know, if we go into these things, is the court's understanding of privilege such that the minute we touch on these doors, they're blown open and the winds of waiver are blowing across us, or whether it would take what I believe is the test, are voluntarily eliciting the confidential communications of our clients to Dr. Oziel before we could be said to have waived the privilege which covers confidential communication.
Well, first of all, in regards to what it is that people will be permitted to go into, that will depend upon, to start with, what it is that they want to go into. My understanding is that that has already been the subject of hearings in this court. What they were going to go into was the subject of the hearing we had, where we went through at the defendant's request the dictated notes of Dr. Oziel, and those portions that were the subject of dispute were bracketed by the defense, and we discussed it. So I assume those are the areas the prosecution is going into. If they're going into other areas, I'm certainly not aware of that. And until they ask questions, I have no idea what their evidence will be, other than what was presented to me by counsel. And beyond that, as far as what the defense does and whether that will constitute a waiver of a privilege, generally, that cannot be answered until the questions are asked and the area is explored. You want advisory opinions in advance prior to the area being explored, and it can't be done. There's no way that I can give you a scenario that would encompass everything that might happen during the direct and cross-examination of Dr. Oziel. So to expect me to tell you when it would be, if ever, that there would be a waiver of privilege, it's unrealistic to expect the court to be able to do that.
Well, I don't think it's that difficult. I mean, if, for example, what does the court understand to be the effect of the waiver that Eric made in telling Detective Zoller that Oziel was his therapist? Has he waived that therapy, all that prior therapy?
I haven't heard that the prosecution intends to go into that. And again, I don't see any need for the court going into areas that the prosecution is never going to touch on and give you my opinion about things that will never arise during the course of the trial.
But what if I want to prove that Eric saw Dr. Oziel from September 30th, 1988, on on X number of occasions before the death of his parents? I do need to know what the court's understanding of privilege is before I'm going to ask those questions. But I think those are very important questions, and I don't think they waive the privilege. But if I'm wrong, I don't want to just stumble in and then we're at sidebar and the court said, well, you just blew it. I don't think it's fair to leave us in that position on an issue as vital as privilege. So I guess what I want to discuss is, I want to ask that question. Now, is the court going to consider that a waiver of privilege so that the content of Eric's X number of sessions between September 30th, 1988 and August 20th, 1989 are now no longer privileged? I need some guidance on that.
All right. Well, again, I don't know exactly what you are going to ask and in the context in which it's going to be asked. You're presenting the court with an incomplete picture and asking the court to rule in a vacuum, and the court can't do that. If you want to argue this further, you indicated that you felt that you were not prepared to do that this afternoon. You told the court you were tired and didn't want to do it today, so I'll give you until tomorrow morning to argue the matter.
What I would like to be able to do is give the court some specific offers of proof, because I can't just do an experiment with Dr. Oziel in front of the jury and then find out later what's happened. I'd like to give specific offers of proof. And what we can do, if it helps the court, is we can do it after direct, so the court has a better idea of where Dr. Oziel is coming from and what the people have elicited. I'd like to give specific offers of proof so the court can then give me some idea of whether or not it feels that asking those questions somehow waives the privilege.
All right.
Would that be
Well,
more useful?
if you want to do that, we can discuss it further. My inclination is not to permit that, because no matter how critical you feel this issue is, it's just like any other issue that's presented in a trial, and counsel don't normally expect the court to rule in advance and give you a preview of what it is your trial strategy should be, and give you the ruling so that then you can tailor your examination and your trial strategy to what you anticipate the rulings to be. We'd have a three-dimensional chess game that would not be the way a trial should be conducted. It's normally conducted where questions are asked, objections are made, rulings are made, and the trial proceeds.
There's one other matter, Your Honor, and that has to do with Dr. Oziel's appointment books, which were seized pursuant to the search warrant and are here in the court. We need to utilize those appointment books in cross-examining him on certain areas. Now, what we don't need to do, and I'm sure he and his lawyer tomorrow would object if we tried to, but what we don't intend to do is to reveal the names of the patients that are listed in those appointment books. But the appointment books are otherwise relevant to our cross-examination. And what I was going to suggest is, I don't think the people, although we've looked at them in the past, and I looked at them again today, I don't think the people have ever seen them. We have no objection to the people seeing them at this time. I don't know what Dr. Oziel's attorney would say. I don't know if they have standing in any event, but we have no objection to the people seeing them.
Well, Dr. Oziel has standing to raise the privilege on behalf of all his other patients who have rights as equal as your clients in regards to psychotherapist patient privilege.
Exactly. But the point is that we're not going to be revealing the names of those patients. We can, in fact, take them make a copy of that book in X amount. The point, though, is to show his practice habits and other aspects that are revealed through those appointment books, including, if we decide to use it, the appointments that he had with our clients in 1989 and 1990, which are reflected in those books.
Well, I number one, I think before he testifies, and this was clear from his testimony in this court when he was here last week, he should be shown those things before he testifies, because his recollection is based on events that occurred in 1990, 89, or 88, whenever these events occurred. And there's a lot of examination that seems to try to pin him down to a particular date that could much more effectively be accomplished if he has access to these too. And it's my understanding he does not.
I have no problem with him having access to them. My only concern is the people haven't seen them, and I don't want them to argue that.
No, I think they should see them as well. And since the defense has already been provided with access to them by some other court in some other proceeding, there has been a opportunity for the defense to see them. So it's no longer something that is being disclosed to the defense for the first time. So if you intend to use those documents and feel that they will become relevant during the examination of Dr. Oziel, I would direct that you redact it to remove reference to other patients.
And the
Of
court has to
Dr. Oziel.
release it to me. I don't have copies. We've never had copies of those documents. We've only had the opportunity to examine them. And all I did in court today was examine them and take notes. I've never had, the only thing I've had a copy of is the billing statements to our clients. And those I'm not intending to use at this point. But Dr. Oziel's appointment books have never left the possession of the court and have never been copied. So I
Right,
don't
but you have seen them before.
I have seen them just the way I saw them today, sitting in court and looking at them.
All right.
And I have no objection to the people looking at them right now.
Well, again, Dr. Oziel is the person who would have to state his objections based upon the identity of all these other patients who are identified by name in those records.
If the court wants.
What I will do, no, I don't think it's appropriate to release them. What I will do is have the clerk Xerox those pages, and that's the only way it can be done. And then it'll be available for you during your examination tomorrow. And well, unfortunately, it's not the type of thing that I intend to release to counsel. And it might prolong the examination of Dr. Oziel, depending on what sort of redactions have to be done. So she can do that tomorrow morning during this hearing that will be conducted.
What I was going to propose, Your Honor, is that in using those records with Dr. Oziel, there is no reason for the jury to see them, and there is no reason for him to mention the name of any patient, nor would I ask him. If those records were admitted in evidence so that they would be going to the jury, that would be the appropriate time to just black out the names of all of the patients, when a third party, which would be the jury, would have an opportunity to see it. I have no doubt that the people would be subject to a protective order from the court that they not reveal the names. So I don't see the need to redact or reduce them. And in fact, it may be difficult to do that because there's some data there having to do with the nature of multiple patients that Dr. Oziel would have to see in order to be able to answer certain questions before we could. For example, there may be an entry, for example, that says, and I'm making the name up, Johansson family. Or there may be an entry that says Krulowitz children. And those issues may be relevant. He sees families and he sees children. And he sees parents and he sees siblings and he sees them all at once. May be relevant ultimately. And so my suggestion would be to use a copy, and if it is used and if it becomes an exhibit, and if it's gonna go to the jury, that would be the time to redact. That's just a suggestion.
All right, well, in that regard, then, I don't see any need to copy it at all. Just tomorrow morning, after giving Dr. Oziel an opportunity to be heard, if I determine that it's something that all counsel should see, then I'll make it available, the original available to all parties, and copy it only if necessary.
And the other thing, Your Honor, is we would like a ruling on the in-camera hearing that we have held concerning attorney-client privilege before we question Dr. Oziel.
Okay,
Your Honor, may I be heard on that?
yes.
We were not privy to any of the testimony. We have no idea what was contained there. And it's been our position throughout that that this issue is not germane until the defense tenders their emotional condition in their case. And I would like an opportunity to, I have no idea what Mr. Chayla testified to. And I would like an opportunity to brief the issue of the overlap of the attorney-client and psychotherapist patient privilege, and also to argue it before the court makes a ruling, because we're again operating in a vacuum. And first of all, I don't see how the court can even make the 1016 ruling upon which this attorney-client privilege has been raised until the defense tenders their position. And more importantly, I think we should, even though I understand why we can't be privy to the testimony, I think I have some idea of what it might have been and some arguments I'd like to raise.
All right, well, certainly the court is interested in the views of the prosecution. This is the type of hearing that is conducted in camera where only the defense presents its side of the evidence, asserting the privilege, and its view of the law, which has been cited by the defense in 2 Supreme Court cases. And that has been the totality of it. And certainly the court is interested in input from the prosecution as well. And as far as the timing of the ruling, if it requires further briefing or argument, then it will have to be delayed. I can't deprive the prosecution of an opportunity to argue this matter and be heard when this was an issue that has arisen just in the last week or so, and the prosecution has not had an opportunity to present their views.
Well, Your Honor, for one thing, this issue did not arise in the last week or so. Going back to the first time I spoke to Mrs. Kuzanich after the Supreme Court ruled, she said to me, you were going to raise the attorney-client issue anyway, even if you didn't prevail on that 1211 tape on psychotherapist patient privilege. Yes, I said to her, we were. She said, that's what I told everybody in my office. So this is not new.
Well, it's new to me in that this was only brought to this court's attention last week.
But the prosecution has always known that this was another issue having to do with those tapes. And the only reason it wasn't litigated is because we never believed, and we still do not believe, that 1016 should pose a threat to the already ruled privileged tapes. But since they have filed that motion, and only recently, and since the court has reserved ruling on that motion and won't give us an indication of what would or would not constitute a waiver of 1016, then we did have to litigate this attorney-client issue, which we never felt we would have to litigate since the time that the Supreme Court ruled on psychotherapist patient privilege. Moreover, the people knew Mr. Chaliff was here, and they knew he was here for that in-camera hearing, and if there were cases that the people sought to cite to this court, they had all week to do it.
Mr. Chaliff was here yesterday,
I know,
not all
but he
week.
was coming before yesterday.
All right.
Yesterday is all week, Your Honor, it's only Tuesday.
That's right. That means yesterday to today, and
But my
everyone's been
point
in
is-
court all day.
My point is, as I indicated before, if I wanted to question Dr. Oziel on his record keeping, let's say hypothetically, and if I were to know, for whatever reason, he didn't keep any records after December 11th, and if I were to even make reference to, did you keep any records after December 11th, I need to know, am I waiving the privilege on December 11th merely by alluding to its existence? Now, I don't believe that's possible, but one is.
Well, if you don't believe it's possible, and if you don't believe that it would be a ruling that any rational, reasonable court would make, then why are you saying that this court would do otherwise?
You've surprised us a number of times.
Well,
You've been here, I mean, you just have. Now, maybe it's because, we are somehow out of sync or out of touch.
No, I've made rulings that perhaps you've disagreed with, but,
You've made rulings that have surprised us,
Okay.
which is different than disagreed. And then you've made a few that haven't surprised us, nor with which we have disagreed.
Right.
But I just can't tell, because there are some things, frankly, that I thought you would rule a certain way, and you have surprised us. That's why we're so skitterish.
well, skitterish doesn't necessarily make something germane for a ruling before the issue arises, so.
But with an issue this significant, which we've tried to be so careful about, and which is complicated, and I don't think should be decided, or can very effectively or consistently be decided only when the questions are popping out of the witness and we're making objections, I think the court could establish some guidelines, as we are asking it to do.
Well, in a general sense, I've already stated my position that these are the types of things that arise when questions are asked and objections are made and the court makes rulings. And that's normally the way it is. And although areas of great sensitivity to the parties, that doesn't necessarily change the way a trial is conducted. And the legislature and the electorate, when they pass certain laws, provide for pretrial rulings on certain matters, and other matters are dealt with during the course of the trial. And the subjects that you're now raising normally are dealt with during the trial as they arise, and not in anticipation of them arising and asking for advisory opinions from the court. So that's basically my response to your request, that these things, other than those areas that you have specific objections to the prosecution going into in its direct examination, these are things that most properly await their being raised during the course of the trial. And if they don't get raised, then the court doesn't make any rulings. The hazard in what you're suggesting is that you'll present the court with a hypothetical situation and ask the court for a hypothetical ruling, and then base any appellate review on the fact that something like that has occurred, which might never have arisen during the course of the trial. That something would never have happened, but you ask the judge, well, judge, could you give me advice on this hypothetical situation and give me your ruling in advance? And then you say, well, I didn't pursue that area because I was concerned about it. And the issue never arises, and it's never before the court for final ruling, and it's never properly the subject of a ruling by the court. So my view is that you're really asking for the court to give you all sorts of hypothetical rulings on situations that might never arise.
Judge, I'm sitting here smiling because my mind just doesn't work that way. I mean, it never occurred to me to try to trap a court into committing in an area that I don't really intend to go into to set up a false issue for appeal. I mean, I'm not that convoluted. That's not at all. Let me assure the court that is not at all what we're doing. I can show you my cross-examination outline. I want to ask these questions, but if the court were to say, if you ask those questions, yes, I believe the privilege is waived, I would not ask them. But I will commit under oath, I want to ask these questions. But I will not ask those questions, balancing the risk of waiving privilege for something that I don't want.
Yeah. Then you're going to complain that the court gave you an indication of ruling a certain way, therefore you didn't ask these questions, therefore you're deprived of the right of cross-examination.
Well,
That's basically what you're
Judge,
saying.
if I do ask the questions and you then rule the privilege is waived and you're wrong, we have that issue. So what's the difference?
Well, my view is that unless the issue arises and is actually perfected, we don't know if you'll ask those questions. So we'll just have to wait and see what the questions are. Mr. Burt, you were going to say something.
I think Your Honor was indicating a different result with respect to the attorney-client privilege argument. And I'm wondering whether we could go forward with that tomorrow. We'd be glad to look at people's cases and be prepared to argue them tomorrow. I think it's an issue that needs extensive briefing, and we do have an interest in bringing that issue to resolution.
Unless the people are willing to stipulate that issue, that the privilege on that tape cannot be waived through cross-examination of Dr. Azil unless he has asked for the content of that tape. If they're prepared to stipulate that the only way that the privilege on that issue could be jeopardized is if after we put on our case, we have somehow jeopardized it under 1016. That's a different issue. But our concern is that questioning about just record keeping or other things about Dr. Oziel would be found to waive that privilege, which has nothing to do with it. See, if we can lock it up under attorney-client, it doesn't matter what we do. We understand that.
All right, I think everybody understands that, but the prosecution has indicated that they don't feel the entire issue is germane unless and until the mental state of the defendant is put in issue during the defense case. And that's my understanding of what you've said, and you wouldn't feel that it is raised by the cross-examination of Dr. Oziel.
The cross-examination of Dr. Oziel as to the sessions on October 31st and November 2nd, I can't imagine would raise issues relating to anything else. But, Your Honor, I think that the 1016 motion that I filed was filed in anticipation of what we think the defense will be, so that the defense would have time to brief it. So that I didn't want to serve it on them the first time they put on a mental state witness and then have them complain that they hadn't been given enough notice. However, it's our position that that motion is not germane unless and until they begin to put on their mental state. In that regard, I believe that the attorney-client privilege has now been raised. And my comments to Ms. Abramson, which I might add, I don't repeat to the court things that are said to me by the defense attorneys, but evidently it doesn't work the other way. That issue only became germane. I asked her that question in regards to whether it would be raised, not whether I thought it was valid. Just because you raise an issue doesn't mean the issue is valid. And so as far as that particular part, it is our position that the 1016 information and that which flows from it is not germane unless and until the defense actually puts on the kind of defense we anticipate. And as far as the December 11th information, at this juncture, I can't commit to any course because I don't know precisely what the defense is going to cross-examine on. Now, but I know we're not arguing this now, but I wanted to posit a couple queries to the court. And one is that it's been the position of the defense throughout these proceedings that the mere fact of making an appointment and going to see a psychotherapist or even an attorney is in itself a confidential communication which cannot be divulged to the prosecution. That has been something that's been raised several times in the past during our pretrial motions. The question I have is, if Ms. Abramson were to ask about the making of an appointment or the keeping of an appointment, is it still the defense position that that is in fact a confidential communication? And would that require a personal waiver on the part of the defendant as to that communication? I'm not trying to be tricky and say that once they waive the privilege as to December the 11th or November the 28th, that means that the mere fact the appointment is leading to a triggering of a waiver as to all the other contents, but it's been their position throughout that the mere fact of making the appointment or going to see the person is itself a confidential communication, which we cannot know about. And if that is still their position, it appears that there is a personal waiver required as to that particular communication. And I'm not saying that that goes into the entire session, but that's just something I wanted to posit to the court because this seems to be a change of position.
Well, Your Honor, what's so strange about hearing that from Mrs. Bozanich is that people are now relying on the fact that Eric, talking to a police officer with no knowing waiver, somehow waived the entire previous year's worth of appointments. Or the fact that he was seeing Dr. Oziel, Dr. Oziel was his therapist because he's telling Detective Zoller to go talk to his friend Oziel, who we went to because of the Calabasas thing. So on the other hand, when they want to use it as a waiver, when they want to use it, it takes no more than a 19-year-old kid talking about it in his aunt's living room to a detective, but if we allude to it somehow, it's a major change in position. Crazy.
All right, we're really getting into left field here. You said something else you wanted to bring to the court's attention.
No, I just wanted to bring to the court's attention this issue of if this is if that fact of going to see the doctor on this particular date is a confidential communication, then does that require a waiver? I just wanted everyone to think about that overnight.
Yeah, that was our original position, and there's no waiver for September 17th. That was our point.
No, the question, I guess, is if the defense asks Dr. Oziel, did Eric Menendez see you on August the 15th of 1988? Does that require a personal waiver from Eric Menendez before the question is asked? Is that what you're asking?
Well, at some point, does that require a waiver, since it's always been their position that that is a confidential communication and we shouldn't know about any of it?
All right. Well, obviously, if they ask the question, the inference is that they're waiving the privilege on behalf of the client, and the client is joining in that. I don't think we need to take a personal waiver from the defendant each time a question such as that is asked. Did you think otherwise?
No, I didn't think otherwise, as a matter of fact.
Good.
But I also don't think that establishing that he had an appointment means that the content of the session is unprivileged.
Nobody has said that, and the prosecution has not said that.
That's all I'm concerned about.
All right. Anything else at this point?
No.
All right. As far as what the prosecution intends to go into, if it is beyond what is contained in the interview notes of Dr. Oziel that were the subject of the hearing, the extensive hearing that we had over 2 days last week, then the prosecution should meet and confer with defense counsel prior to 9 o'clock tomorrow morning, so that if any areas of privilege or other concerns are covered in those subjects, that they can be brought to this court's attention prior to the hearing. And as far as the attorney-client privilege is concerned, if there are cases that either side wishes the court to review, I will review them. That is not an indication that the court regards this as a subject that is to be resolved tomorrow and prior to Dr. Oziel's testimony. I respect the people's view that they have a right to be heard on that subject as well, and I'm not going to deprive them of an opportunity to be heard just because we've had in-camera hearings where they have not been present and are not privy to the precise information that was provided to the court. They still have a right to be heard on that subject and to present me with any case law or authority or argument that they feel is appropriate.
Have no objection to that. My only question is the court ruling that that should be done tomorrow? In other words, if both sides have cases or authorities they want the court to be aware of, we should show up tomorrow morning with those authorities so that the court can then go forward and make a ruling at some appropriate time.
If everyone has everything ready and it's prepared to be presented to me, and it will not delay the commencement of Dr. Oziel's testimony at 10 o'clock, I'll consider it. If all those things are not met, I don't regard this as something that prevents Dr. Oziel from beginning his examination. All right, so we'll be in recess until tomorrow at 9 o'clock.